Yes, a memo. It's a tax matter, my lords. Learned single judge dismiss the writ petition.
Just take that.
What? There's two ideas, one for us.
Just 1 minute, please. See, we take it on Monday only. Now Monday,
My lords, e-credit ledger blacked by the first respondent. 28th is the last date for filing the returns. Me.
What is it? In writ petition.
so
So can you take it for preliminary for tomorrow, my lords? And there is a division bench judgment covered by
what is the order of the learned single judge?
the alternate remedy is there. You go file appeal the learned single judge said, my lord.
Have it tomorrow. This is our jurisdiction and just check it. No, have it tomorrow.
My lords,
We'll have it tomorrow.
Yes, ma'am.
my lords, I appear for the app.
Commercial levy. One memo for release of amount, one.
Just take
for,
that memo.
Time for the response.
What is the urgency?
It's a release of amount. That amount was ordered to be deposited.
Have you filed any application?
Yes, application is pending.
What is the number?
Application number I have not checked yet.
See, you have to get that clear number. Application need to be without any objections.
Yeah, it is not, there is no objections. I have to check.
Copies of my-
Not.
Who appears for the other side?
Other side, Kumar.
So you have to inform them.
He knows. I have served the copy and
No,
I will inform.
and this is only an application for the release of the amount. We can have it after vacation.
Yeah, no problem, but
Then do one thing, take this back. You mention it on the opening day for the listing. That would be better.
My lords,
Yes.
I appear for the appellant in a commercial appeal. My lord, this honorable court had referred the matter for mediation and it has hence been settled and a settlement agreement has been signed. My learned friend for the respondent is also present.
Parties will be present, my lords, on video conference.
Have you filed any application? Is the settlement on record?
Please, my lords.
Please, my lord, the settlement is on record. The mediation
Have you
report.
filed? What have you filed?
But the mediator's award is on record.
The mediator has filed his report.
Please, my lord.
Please, my lord.
It's on record. So we'll have it.
Tomorrow, my lords, parties will be
How
present.
many matters are there tomorrow? Nine and 230 matter. We have 230 matter also. Huh? 30. No 230 matter, no? Then have it tomorrow. We'll have it tomorrow.
Much obliged.
We'll just note it down for tomorrow. This and that and in the register also.
Your lordship,
Yes.
I'm requesting for an adjournment, your lordship.
We'll come back to the adjournment. In today's list, no?
Yes, sir.
We'll come back. Any other mentioning? Okay, call the list. ma'am.
For adjournments. Page number 8, 34 to 36. Page number 9, 37 to 43. Page number 10, 44 to 47. Page number 11, 48 to 53.
53, my lord.
Hmm?
53, my lord.
Mm-hmm.
For the appellant, I informed my senior advocate, Mr. Bhagwan.
Appear for respondent.
Mane,
Appear for respondent number 1 and 2.
You,
after vacation, my lord, because there's a marriage function in the house, my senior office, a house.
marriage in the house.
Her niece, the marriage,
Pardon?
my senior niece
Oh.
marriage.
At the request of counsel for the appellant renote, which is not opposed, adjourned to,
My lords,
February.
serial number 50, my lords.
One. yes.
But still number 52, my lords, there is a direction as to file written submissions. Written submissions have been sent to clients for approval, my lords. We'll file it this week, my lords.
Who appears for the other side? Have you informed?
Yes, I have informed Mr. Dilip, my lords.
You have informed?
Yes.
At the request of counsel for the appellant, re-notify on the counsel for the parties to file the written submissions before the next date of hearing.
Please, my lords.
Yes, ma'am.
My
Order
lord,
of
My
February.
lord, serial number 50, my lords. I seek for a short accommodation. We have engaged a
The other
senior
side,
counsel.
ma'am.
My lord, hits
At
CG.
the request of counsel for the appellant, re-notify on.
3rd of February.
my lord, serial number 44, man.
1 minute, please. Yes,
Serial number 44, I am appealing for respondent.
who is for the appellant?
For the appellant.
What is Mr. Sanmati says?
Yes, madam, your lordship, I have to get instructions, my lord.
You were to take instructions.
I'm still not yet received, my lord.
At the request of Mr. Sanmati to take instructions, re-notify.
3rd
Did-
of February.
Did we say so on the last date?
But I'm sorry, my lord, because officers, I could not get in contact. with my-
No, did we say so to take instructions or you want
Yes, my
to?
lord.
Okay, just re-notify.
My lords, 51 and
Yes, 1 minute, ma'am. Let's give a date.
For 3rd of February.
Okay,
my lords, 51 and 54. HCGP appears from the 51
yeah,
and 54, my lords.
yes.
My lords, a short
What are
accommodation might
connected
be.
matters, ma'am?
No, my lords.
Who appears for the respondents in those?
I appear.
matters? You appear in which matter, Mr. Bhatt?
51 and 53, my lord, 54.
54.
Both,
Yes, madam. These are matters against the
but
state.
they are not connected.
They're not connected at all.
At the request of counsel for the appellant in both the matters, adjourned to
3rd of February.
My lords,
Obliged.
serial number 58, my lords,
50.
58.
Okay, just 1 minute, please, ma'am. Call the next page.
Page number 12, 55 to 56. Page number 13, 57 to 62.
My lords, 57 serial number.
57, no,
It's
yes.
below monetary limit, my lord.
Appear for the appellant, it is less than 2 crores, my lord, it can be closed.
Who is the appear?
Your lordship, he is amicus curiae appearing for the respondent.
Yeah, Micus. Now, this would be being less than two,
Less
you
than
don't,
two
you will not press it. Just say, Mr. Sanmati states that he has instructions to state as the tax effect in this appeal is less than 2 crores, comma, the appeal shall not be pressed. Stop accordingly the petition. The appeal is dismissed as not pressed. That's right?
My lords,
Yes.
serial number 58, my lords. I am for the appellant. I've informed the other side.
I appear for respondent, my lord. A date may be fixed finally, my lord.
At the request of counsel for the appellant for an adjournment which is not opposed, adjourn to. In February, ma'am.
10th of February.
Yes,
At least January.
not possible. Next.
Your lordship, serial number 61, I'm appearing on behalf of the respondent, your lordship. We need to file a paper book, your lordship.
Who is the appellant?
Dilip, counsel Dilip, your lordship. I have informed,
No, the paper, who has to file paper book?
we defendants, your lordship.
You have filed or they have to file it?
They have to file.
No, we have to file a rejoinder and along with some other documents, your lordship.
What other documents?
A few case laws and
Make a request. Why are you making all requests? Yes. What? What? Have you filed your rejoinder?
We have.
we have to file, we are respondents, your
filed.
lordship.
Obviously, rejoinder, they will file. Who will file?
We have to file objections for the appeal and few documents.
Who has filed the appeal?
The
No, it's a
depart-
revenue appeal, my lord, they want to file objections.
Objections not rejoinder. How do you say that it is rejoinder?
No objection, we are in appeal. What is this? Is the complete record here? Is the complete record here?
Please, please.
Have you filed it?
No, it's, my lord, our paper, our
Has it
papers
been-
are ready.
Has it been admitted?
Please, my lord, it's come for final hearing.
Okay. Admitted,
It's,
na?
yes, it's for final hearing.
The, will stop. Now, at the request of counsel for the respondent, for an adjournment which is not opposed, re-notify all.
3rd of February.
Next.
My lord, serial number 56, page number 12. Seek a short accommodation, inform the other council, my lord. 56.
Who is the other
Public
side? Mr. Sheshadri,
park matter.
you appear for whom?
I'm for the respondent number 4.
Taken Mr. Sheshadri's consent?
Yes, my lord. Yes, my lord. Just the conflict.
We were ready to hear it, Mr. Sheshadri.
I don't know, my lord. But if the council is not well, my lord,
Then we take it.
with 50 years of experience, I never,
You're right, you're right.
immediately after vacation.
Yes, you appear for which number?
R4, R3, my lord. Club.
R3,
Second.
request for adjournment is made on behalf of the counsel for the respondent number 3 on the ground that he is unwell.
Yes, my lord.
Re-notify and just immediately that 6th or 7th No, immediately opening.
Sir, 8th of
Serial number-
January,
Huh?
8th of January.
Not eighth, my lord, I have a commitment, any other,
Yes, what is convenient?
sixth, fifth or whatever.
No, it's sixth,
Or
seventh,
10th.
ninth.
10th, 12th.
Ninth,
Reopen.
whatever.
Reopening immediately.
Huh? Ninth is fine, my lord, subject to the convenience of the court.
Ninth would be fine,
Yes, sir.
ninth.
Much obliged.
January.
Please, my
Much
lord.
obliged.
Serial number 35, my lords, for the appellant. Serial number 35, my lords, for the appellant.
Going back,
Please,
yes.
sit for a week time, my lords.
Yeah, what is the difficulty?
My lords, I'll have to seek some more instructions, my lords.
You are for whom?
For the appellant, department appeal, my lords.
What instructions?
My lords,
Who is the other side?
my lords, the notice is still not been issued, my lords.
Oh, no, but they have also filed an appeal. There's a cross appeal, I suppose.
My lords,
That's right.
please.
So we'll adjourn 35, we'll retain 36 then.
Fine, my lords.
But it arises from the same order. This order challenges the service tax appeal, na,
Please, my lords,
of the tribunal,
please.
17-2.
Pertains to wrong availment of Senmat credit.
Hmm. Ma'am, just show us the file, 36 file, ma'am. They are different. Okay. Just say that at the request of the counsel for the appellant in item 35. Re-notify
3rd of February.
all the list.
Number 1.
Yes, Mr. Tiwari.
My lords, this is a Supreme Court remand matter, my lords, transfer pricing matter. My lords, there are two office objections, my lords, regarding the legibility of the document, my lords. That, my lords, at the time of hearing, my lords, will produce that, my lords.
Illegibility of the document.
Yes, my lords. Some documents are not legible, my lords. Because, my lords, what has happened is they have put the photo.
In case, Mr. Tiwari, we'll await that judgment.
Yes, my lords.
In the meantime, why don't you file it? The type copies,
I'll file it, my lords.
do that. This, just say that the registry has notified two office objections, which includes the, which includes that pages number 168 and 214. Which includes the following, just 1 and 2 reproduce it. Mr. Tiwari states that the objection shall be cleared within 2 weeks, within 4 weeks. Full stop. Has it been admitted?
No, my lords.
Full stop. Yeah, okay. The objections be cleared, just re-notify the appeal. So we will not say anything. Let's see that. Have it after 4 weeks.
10th of February. Serial number 2.
My lord, I appear for the respondents.
Yes.
Lord, this was urgent for my submission. But
Ah.
this is the matter where the issue is whether the payment was made under coercion.
We'll just pass over Mr. Kamath. Let's see. Then we'll take it up.
Would your lordship take up at the end of the admission list, my lord?
Should be that way only. Once we take it, the first round is over. In the passover,
Very.
Obliged.
Serial number 3.
what is the office of the? Yes.
During the adjudication proceedings under the Customs Act,
Hmm.
whether the party has a vested right to seek a cross-examination of the officers and the witness. That's the only issue. On that ground, the tribunal remands it. In spite of all the documents being given to the importer, respondent, and he never raised an objection. having participated in the, my lord, all the proceedings. My lord, for the first time, my lord, in the tribunal, it says that, my lord, before the commissioner appeal, he said that the opportunity to cross-examine the officers.
But otherwise, what is the process? Is this a summary process or what is the process generally is followed?
Definitely, my lord, the show cause notice is issued. Along with the show cause notice, all the relied upon documents are furnished to them. My lord, they have to, my lord, give a reply, my lord, on the basis of that reply, my lord, the personal hearing will also.
Then
be
how
done.
does the tribunal gets this right of cross-examination?
That's the issue.
You appear for the respondent.
My lord, I am appearing for, they have to comply the office objection, my lord, it has come
It's
for.
only one objection.
My lord,
What is that objection?
Advocate
Legibility?
has,
I comply.
advocate has to appear from, because it is for non-compliance of office objection.
What is the objection, man? It's annexure, she is legible. Let's see what is the C annexure.
Order to original, that original order passed by the, my lord, the adjudicating authority.
Which is the page? Forty-five. It's all right, we will overrule it. We can read it, it's all right.
Others can admit it. Most of
My lord,
We will
kindly have it next week, my lordship, the advocate will,
just say this, the objection in respect of annexure C being not legible is overruled. Just say that having seen the annexure C, the appeal on which objection of the appeal on which objection has been raised by the registry being illegible, comma, the same is overruled. Full stop. Okay, my mistake. You see page 60, page 60 and 56. You've seen that?
Yes.
I think you have to file. Just cut that.
Immediate application.
Yeah, just the compliance to the office objection be made within how much time? Within 2 weeks. Your honor before 6th of January 2024, list on. Just give it January, February, whatever is convenient.
13th January. Serial number 4.
I appear for the applicant in the matter, my lord. Respondent number 2 to 4 required to be served. I'll take steps as against them, my lord.
They issue notice to the respondent 2 to 4, returnable on.
10th of February.
Grateful, my lord.
Serial number 5.
Lords, in serial number 5, I beg to appear for the petitioner, my lords.
For the respondent in the first matter.
Who appears for 8 to 10, 8 to 14.
MRC Ravi has become designated senior counsel. For that reason, my name may be shown, man. Prashant.
You file your wakalat.
I will file my wakalat.
You should just say that so and so appear. What is a good name?
Prashant VR.
Mr. Prashant VR appears for respondents 8 to 14, states that he shall file wakalat within 1 week from today. That's all are served now.
Please.
We notify the appeal on.
My lords, may I make one submission, my lords? My lord, despite there being an interim order, my lords, in this matter, the GST authorities are now precipitating the issue, my lords.
If they do anything, you have a recourse. Take that.
Please, my lords.
There is an interim order.
There is, my lord, it subsists. Maybe extended, my lords.
Just show us that, please.
Interim order was passed on
Appears,
8/3/2022.
Mr. Bhatt, you appear?
That's for the state government, my lord. The first respondent is the Union of India.
Interim order, the interim order, if any.
My lord, this is dated 8/3/2022, my lords.
That's right. Is extended till the next date of hearing. Who appears for the other respondents?
Works contract. Chandrasekhar.
ಹಾಕಿದ್ದೀರಾ ನೀವು ನಿಮ್ದು ಅದು ಇವರ ಅಪೀಲ್
5.1 ಬಂದಿದೆ.
Who appears for this 1, 2, 3,
My lords,
4?
for one, Mansi Kumar is appearing, my lords.
Central.
I mean, tell us, is there any amended memo of parties? See the memorandum of appeal.
ನಾವು ಎಷ್ಟನೇ ಪಾರ್ಟಿ ನೋಡೋಣ
Why are they saying this 8 to 12?
ಕನೆಕ್ಟೆಡ್ ಅಪೀಲ್ಸ್
My mistake.
ಅಲ್ಲ ನಂದು ಇದಾಗಿದೆ.
Who appears for, then Mr. Bhatt, you appears for, and Mr. Nilagiri, you appear for,
For the state government, my lord, I think.
no, Mr. Nilagiri.
My lord, I appear for
1 and 2.
23537, my lords, around. Writ petition number.
Yes.
No, not 5. You appear for union.
Yes, my lord.
2 is Goods and Service Council.
Yes, my lord, 2.
Then come to this principal commissioner of
Four.
central tax. 4.
4. 1, 2, 4. My lord.
6.
6, my lords.
1, 2, 4, 6.
Yes.
Mr. Nilagiri and Mr. Bhatt would appear for
My lords.
2, 3, 7.
My lords, not two.
Why not?
2 I have taken.
The Goods and Services Tax Council, my learned friend appears.
No.
Clearly.
Oh, no, see, 3.
3, my lords, of course. 3,
3,
5,
5, 7,
7,
8.
8 I will appear, man. 8 to 14 I will appear.
Acha, 8 you will appear.
No.
Then 3, 5, 7, Mr. Bhatt. And rest 8 to 14, he will appear.
My lords, now what would happen, my lords? I'm claiming parity, my lords, in respect of this matter, my lords. Since
See, we will see it. There is an interim order which has been there.
Yes, my
We'll
lords.
just continue.
My lords, what would happen is they have challenged it, my lords, by virtue of a writ appeal, which is listed at 5.1.
Where is it challenged?
My
Before
lords,
your
the writ appeal, my lords.
5.1, the connected.
5.1, my lords, the connected matter.
Which order you have challenged? Other
But
than
the
a
order
single
is-
judge? No. But there is no interim there.
No, my lords, I don't yet have an interim order. There's a short delay of 32 days.
Just 5.1 will condone the delay?
I'll be obliged.
My lords, I'm not appearing in that matter.
Why? You're not.
My lords, since it's a
We-
similar matter, my lords, which was taken up for consideration by the single judge, wherein there are similar prayers, my lords, those
Is
writ
5.1?
petitions came to be allowed.
These are group of, it's a batch of writ
Yes,
petitions.
It's a batch of writ
The
petitions.
question was, my lords, in works contracts, if part of the work is completed before the 1st of July 2017, when GST came into force,
Which will
what is the
come?
effect?
Or the previous regime or the GST regime.
Precisely. And who has to bear the tax impact of that? If I issue a tender, which is all inclusive, and the tax regime changes,
But are these people, are these respondents party here? Who are there in the appellants in the 5.5?
yes, ma'am.
They are parties in 5.1.
Which
Everybody is a
number?
party. If your lordship see my cause title, I have, it may be that my learned friend has not yet been instructed, but my writ appeal is in all the matters.
Just say that objection, office objection be cleared
My lords.
within 2 weeks, on or before, within 3 weeks. List on. Ma'am, in item 5. interim
Lord, in
order,
similar matters, my lords have already issued a notice.
Is an interim order here.
My learned friends matters, the union's appeals, your lordships have issued notice, my lord. It may be listed together with all of them.
No, first clear the office.
I'll do that.
Next.
Great.
27th January. Serial number 6. Serial number 6, Srimati Kavita.
Appearing for the appellates in this, my lords.
Issue to the respondent.
11th of February.
Same in 6.1 also.
7, Akash Shetty.
In this case, I've been freshly appointed, my lords. I'm had to get the paper book, my lords. I'll either secure it from the department
You
or,
require a paper book in a writ appeal. Have you filed all the documents?
my lords, there has been change of council now. The previous council has filed. I've been.
No required is all
accommodated.
paper book. We'll dispense with what is this? You file complete whatever is the record of the writ petition.
It's already on record.
My lords, it is on record, my lords. It is on record.
My learned friend doesn't have a
There has
copy.
been a change of counsel, my lord. That is the reason.
A different argument, surely. You want an adjournment on that ground?
Please, please.
Just say that what is a good name?
My lord, Akash Shetty, Akash
Mr.
Bishop.
Akash Shetty appears for the appellant. Mr. Shetty, you file your wakalatnama. Where is the change of counsel? When did you file it?
My lords, couple of months
Okay,
back, my
the
lords.
request of Mr. Shetty re-notify.
4th of February,
Next,
serial number 8. Niralgi.
Mr. Khan. Yes, Mr. Mittal.
Yes, my lord, last date, my lord has heard this matter
Hmm.
and it has not been objection list. My lord, kindly see the order dated.
Lord, it's
16th
1
October.
minute,
No, it is
just
a-
1 minute.
Lord, it's our appeal. Lord,
Ah.
kindly have it after vacation, Lord.
Okay, we heard this matter.
Yes, my lord.
I have not appeared, my lord.
Good.
I received a request recently, my lord. I need to be
I
briefed.
too
on
have
that.
not
Kindly
appeared
have it
this.
after vacation, my lord. I'll make my submission.
Kindly see the order dated 16th October 2024. First thing, it should not come in the objection list. Check.
You're coming for something?
Who is appearing for the Development Corporation, Road Development Corporation?
My lords, I'm appearing for the respondent number 4, my lords. Respondent number 3 and respondent number 4 in the connected matters.
But they are just performer party here.
I appear for NHI. This for number 3 in first appeal and for number 2 is second appeal.
My lord, office objections have been complied. If there are any, it may be overruled and listed, my lord. Maybe listed after vacation.
Just say that.
I don't see how the respondents have an issue.
Not a partner.
We don't have any issue. You don't have any issue.
My
Don't have
lord,
an issue.
issue was
Alla, our pakkadore submission.
ಏನಂತ ಮಾಡ್ತಾರೆ?
kindly see page 41, 42.
I am the appellant, Lord. I will argue it after vacation.
My lords, we are ready, but if
The
they want time.
single judge's
let
order
them
is
have-
against us. We have challenged it.
Yes, yes.
So
If they
that-
want time, let them take time, my
Yeah,
lords, there's nothing.
The
wrong.
request of
We're
Mr.
ready.
Arvind Kamath, learner senior, learner DSG, appearing for the appellant, re-notifier. Just see, ma'am, whatever is convenient.
27th January.
My lords.
Just one, 27. But any other? Lord, any other day, Lord, 27th,
Whatever is convenient.
20th, Lord, 20th,
28th, ma'am.
20, 20th,
20.
20th?
20th.
Okay.
That's a Monday
20th
as well.
January. That's a Monday?
Yes,
Mondays.
Okay.
I'm correct.
Then
Deeply
unless, also say that objection is removed because it come in the objection list. There is no objection.
Doesn't make any difference, Mr. Mittal. All technicalities, you know, unless there is a substantive objection, you can go ahead.
If you're going ahead, my lords, wherever it appears, it can appear.
But what is the objection?
That's so many objections, my lord.
You know,
May not be germane to the, my lord.
Huh? No, we want to, where are the one non-filing of, no. Non-filing of acknowledgement having served the copies of the advocate. Who appears for respondent number 3?
All are served.
I appear for this for number 3.
That's right, she appears. Ms. Shah, you appear for R3, na?
Yes, ma'am.
Just say that. Have you served a copy?
Yes, I have served.
Yes,
the
my
copy.
lord.
They are all
Copy is
paid.
Just, ma'am, just mark the attendance for Ms. Shah for respondent number 3. That's all. Who else?
Cosly
My lords, I'm appearing for respondent number 4, my lords.
Respondent number 4, just mark the appearance also.
7 I appear.
Respondent number 4. Who appeared Ministry of Road and Transport. You have made Ministry of Government of India.
Yes, Government of India.
It's a perform.
performer. I'll get one of my colleagues to.
Just ask them to appear. I don't think so. They are really necessary. Then Government of Karnataka,
I'll
Mr. Bhatt,
appear.
you would appear. Just say this. One who appears.
One and, respondent 1 and 2. I am
1 and
appealing.
2, Mr. Mittal, NHAI,
I appear.
Ms. Shah,
For number
Karnataka Road Development Corporation.
My senior, my lords, Mr.
She
Manuke.
appears. 5, don't say anything. 7, Mr. Bhatt.
No, 5 also Cosly is more than.
Mr. Madan Pillai, one of my colleagues, he is a CGC, he is a Central Government Council.
Same
We
issue.
don't want to put his appearance.
Yes.
Could be for both. Okay, next.
But can it be 21st or 22nd? 20th batch matters are listed in Delhi High Court.
The only thing, Mr. Mittal, on, we take tax matters on Monday. That's the, you have any difficulty? Monday.
Yes, the batch matters, 40 batch matter are listed for.
Yes, Mr. Kamath, any other date?
Or it can be on February.
Feb 10th, my lord. Feb 10th. 10th Feb.
10th February.
Grateful, man. Grateful.
Okay. Next.
Number 9.
I appear for the appellants.
Yes.
See, two issues, one on maintainability.
See 8.1 who appears for the respondents to the funds. Just ask them to give appearance. Who appears for them? You don't have people. Here the service is effective, huh? This objection. No, she is appearing, no, Ms. Shah.
Yes.
She's appearing, that's all.
Number 9.
Please, please.
Ravi Raghavan.
It's two issues on maintainability. One, my lords, this appeal is maintainable before this Honorable High Court in terms of section 28 KA of the Customs Act. This is an appeal filed against an authority for Customs Advance Authority in Mumbai, and appeals against that lie before this Honorable High Court. In terms of section 28, that's
Just show us that. But tell us, where exactly the impugned action?
My lords, in Karnataka. I am an assessee registered here. Imports are taking place in Karnataka. I have a unit in Mysore. So the cause of action arises in this court.
Why did the authority has decided in
Mumbai? Because my lords, initially there was only one customs authority, advanced ruling authority in Delhi.
Advanced ruling.
Advanced ruling authority in Delhi. Thereafter they opened another office in Bombay. So all matters relating to the south are in Bombay. The other matters go to Delhi. That's why the authority sits in Delhi, my lords, in Mumbai in this case.
Who has raised this objection? The
Registry.
Or they have done it?
Registry, I think, my lords, because it's mentioned in the cause list.
Let's see 28.
28 KA, my lords, may kindly see. KA. In this paper, which I just handed over. And top minutes. Any officer authorized by the board by notification or the applicant may file an appeal to the High Court against any ruling or order passed by the authority within 60 days from the date of communication of such ruling or order in such form and manner as may be prescribed.
That's right. But High Court is which High Court is the issue?
The issue, Manoj, because I am an assessee registered in Karnataka, in Mysore. Imports are happening in Bangalore. Well, let's see in fact, there are imports happening across the country. In Bangalore also, I import in the customs, in the Bangalore customs. So this is an advanced ruling, Manoj, in regard to the imports on classification of clear float glass. So the imports happen here because I use it in the manufacture of my goods in Mysore. Trader.
Mr. Nilagi, you appear for it?
Please.
For this?
Yes,
for the customs. Now tell us one thing. Now, otherwise this, the appellant is based in Karnataka.
Mysore.
Okay. The advanced ruling authority is in Bombay and one is in Delhi. So these are the two. So obviously it's a question of advanced ruling, but what triggered the order of the advanced ruling authority is in respect of an entity which is based in Karnataka. Where will you go?
My lord, both the places, my lord, cause of action lies.
So he has preferred this. What is wrong in this? Just say this. The registry has raised an objection on the maintainability of the present appeal before this court. I would ground that the order under challenge is an order passed by the advanced ruling authority based in Mumbai. The submission of learned counsel for the appellant is that as the appellant is based in Mysore, Karnataka, the appellant is within its right to approach this court challenging the order of the advanced ruling authority. Full stop. He states that ARC may be part of cause of action as a reason within the jurisdiction of the High Court at Mumbai. Is not, the petitioner is not precluded to approach this court. Full stop. Noting the submission, the objection of the Mr. Nelargi appearing for the customs, the respondent's number,
May direct me to take notice.
who appears for the respondents,
All the respondents.
all the respondents do not contest the plea submission made by the counsel for the appellant. Accordingly, the objection of the registry is overruled.
That's my prayer for admitting the appeal in terms of the substantial question at page 31. Yeah. Very questions.
There is only one respondent, Mr. Neelargi.
Only the advanced ruling authority minutes.
Huh?
Please,
Only the advanced
only
ruling authority.
one respondent. I didn't have a file.
Stop. Okay, the notice, Mr. Neelargi, accept notice. Okay, your copy of the appeal.
We'll serve it.
None.
We'll serve the copy minutes.
What do you say on this?
No, I mean, just
Say at his request, re-notify him. Just give it in January and then.
20th January,
Next.
Obliged.
serial number 10. Dilip,
The matter involving the DIN number not being mentioned. My lord, I understand that in the Supreme Court, the SLP is listed on 7th of January. Although, my lord, our contention is that the issue in that Brandex case was different, we can distinguish. But since Jan 7th is closed by, my lord, we can defer the matter to that.
Our contention has been we should hear the matter after Supreme Court. I'm with him on that.
Just show the last order.
My only one submission, my lord, is I am given to understand that serial number 37 in today's list is also same didn't matter.
Oh,
The lordship could also merge it,
didn't matter.
club it, so it will be.
Just say that Mr. Kamath and the DSG state that the issue which falls for consideration in this appeal is pending consideration before the Supreme Court. And the date of hearing is 7th of January.
Please. 7th of January.
7th of January. Accordingly, we notify this appeal on. 37 is also there. Who appears? Mr. Tiwari appears. 37 also same order.
But both may be clubbed also.
We may have it on the same day, Mr. Chen.
Yes, one after the other is easier so that the other.
We will see it. We don't have any report.
It can be had on the same day.
37 also.
15th January,
No, take it further. Take it now. End of February, first week.
the 10th of
10th
February.
of February.
10th of February.
So, my is likely to be taken up.
Serial number 11. Dilip,
Serial number 11.
No, this is a delay of road.
I seek
You
your
have filed a
lordship
better affidavit.
The better affidavit has been given to me today, my lord. Your lordship may post it immediately after vacation. There is one other issue in this matter, my lord. It is a case of a search assessment. The very same addition was made in the regular 143.3 that went to Commissioner Appeals tribunal and also this high court. I would like to put all of them, it can be closed on
The
that day.
SSC succeeded.
Accident up to this, my lord. So I have to place all
I'll
those
have to
records
look into
straight.
the records, my lord, because our contention is, my lord, the additions have been made on the basis of materials, my lord, which were not before the assessing authority in the original round. Lord, I look into the records and,
Just say that, learner counsel for the appellant seeks and is
my
allowed.
lord, delay may be condoned.
No, my lord, delay.
Or- Okay, very good. You have filed your additional affidavit, na?
Please.
Today,
please.
The additional affidavit
Not.
explaining the delay,
Today only.
Copy putting.
explaining the delay has been filed. It's on record.
Please, it's on.
Has been filed. Mr. Shankar Leonard, senior counsel appearing for the SSC respondent, seeks some time to look into the same. At his request, we notify. Why don't you file this thing also, a response to this? To the additional affidavit on the.
I'll
delay?
file, my lord.
Then you can bring all those.
Yes, all those facts I'll bring. So I'll file.
Say that Mr. Shankar Leonard, senior counsel, seeks and is allowed 4 weeks to file a response to the additional affidavit. To the application seeking condonation of delay and also the affidavit, additional affidavit. On both you file it. Within 4 weeks, re-notify on.
3rd of February. Till number 12. Till number 12, Shri Sanmati Indra Kumar.
Yes,
Your Lordship, I appear for apparent. Your Lordship, the tribunal has followed the decision of this honorable court passed by the learned single judge in the case of Flipkart. That decision has been challenged before this honorable court in writ appeal. It is coming up on 13/1/2025.
Lords, Flipkart follows the division bench judgment of Abbey that is recorded in the order. The division bench has already considered this question, decided. I can show from the judgment. And all
Flipkart attained finality.
Flipkart was a single judge decision in a writ, but the learned single judge followed the division bench judgment in appeal of this honorable court.
What happened to that division bench?
My lord, that has been finalized.
Which is the case? What is the name of that case? The division bench?
My lord, that is Abbey Services. I have a copy of the judgment.
What do you say, Mr. Sanmati?
Your Lordship, I will just verify it, my lord.
Just verify.
Similar matters are coming up on 13th, my lord. It may be taken up,
January.
it's 13 January, my lord.
How many matters are
Your
there?
Lordship, writ appeal number, my lord, one matter is there, my lord, on 992 of 23.
We can do one thing. Why don't you file a compilation of all the orders?
Very well, my lords, I can do that, but the tribunal is itself recorded. And they are aggrieved with this, that the tribunal has followed the Abbey decision, which is the division bench judgment.
Seal number 22 is also same, my
Just
lord.
say that at the request of Mr. Sanmati, that identical matters are coming on 13th of January,
Yes, my lord.
2025. Re-notify this appeal on this. Just give the details of that matter.
Yes,
Which is
ma'am.
the other matter, Mr.
992
Sanmati?
of
My lord, that is the Flipkart judgment that he is referring to.
992 of 23.
That is
Writ
Flipkart,
appeal, judge.
not my case.
Not your case, but
Not my case. That's
issue is identical.
We are saying identical issues, not this appeal. I didn't know which is the other appeal.
Serial number 22 is also same.
22. Who appears in 22? Do you appear in?
My lords, we appear in 22 also. Same assessee.
Oh,
It's a common order of the tribunal.
we will do one thing. We'll have it on that day. 13 January. Okay, next.
There's a delay also.
A delay of 51 days may kindly be
You
considered.
say,
That we are not opposing.
just say that in item 12, this is an application seeking condonation of 51 days delay in filing the appeal for the reasons stated in the affidavit accompanying the application, and also the learner counsel for the appellant respondent has no objection. If the delay is condoned, comma, the application is allowed and the delay is condoned and the application is allowed and disposed of.
The same order may kindly be passed in 22 also, my lord. Serial number 22.
How much is the delay?
Same, my lord. Connected
my lord.
matters.
Okay, same order in the other third.
22.
22.
Serial number 22. Grateful.
Till number 13.
Your Lordship, 13, my lord, I may be permitted to serve the notice to the assessing officer, my lord, by taking hand summons, my lord. Thrice I have taken, my lord. This is third time I have.
Let fresh notice be issued for service on the respondent. Additionally, liberty is granted to serve the respondent through the assessing officer.
Yes, my lord.
Through the assessing officer. for the returnable date.
10th of February,
Please, my lord.
14, Pradeep. Here, Pradeep.
Lordship, the office objection is that the assessing officer has been made a party for this writ, this appeal. Because he passed the original assessment order, whereas my prayer is to set aside the order of the tribunal.
But assessing officer is not required. Why do you want? These are all quasi judicial proceedings.
Yes, I cannot make tribunal a party.
Okay, okay. But you can still make the board as a party.
Lordship, generally the commissioner and the assessing officer.
What do you say, Mr. Sanmati? Is the assessing officer not made a party?
You just traders, so we have made assessing officer a party.
Your lordship,
14th.
your lordship, assessing officer as well as the commissioner, my lord,
They are
both are
made
necessary parties, my lord.
Necessary part.
Yes, my lord.
Okay, very well. Where is the memo here? This is against the assessment only?
This is against the assessment, which has culminated into order of the tribunal.
Okay.
There are,
Where is the objection, ma'am? There was R2, IT order. The R2 was not a party before IT-AT.
Lordship,
Respondent number 2 was not a party before IT-AT. That's the objection. And they are right.
generally, Lordship, because he has a supervisory, this thing, appeal is always filed against.
Will that make any difference if we make only ACIT a party?
Yes, not, I have not.
So we will retain respondent number 1 as a party. Then whether you have. the
Assessment
memo, Mr.
unit,
Your lordship,
That is a
the
faceless
second
assessment.
respondent is the present assessing officer, my lord. The first respondent was the officer who has passed the original leave, my lord. So there is no requirement for a second respondent, my lord.
That's right, we will delete it.
Yes, my lord.
But 3 would be retained.
Yes, my lord.
We'll
3.
retain 3. You find,
Yes.
just say this. The objection of the registry is that respondent number 2 has been made a party, though the said authority was not a party before the
Lordship,
80-80.
this whole process is a faceless. The second party is a faceless officer who has also done the assessment. First party is the one who continues post assessment. That's why both are necessary. 1, 2, 3, all the 3 are necessary, but I leave
Why
it.
didn't you make respondent number 2 a party before IT-80?
Lordship, before the IT-80, respondent 2 was also a party.
No,
Because
but was
No,
it a
it's not.
party? No. You see the order at page 40.
my apologies, Lordship. My apologies.
So now.
Then
that's
1
the
and
reason.
3. 1 and 3.
To stop, as the respondent number 2 was not a party before the IT-80. This, the objection of the registry is justified. At this stage, learner counsel for the appellant states that he shall delete respondent number 2 as a party respondent by filing a fresh amended memo of parties. Necessary correction be made in the memo of parties as well. Okay, within on or before 7th of January 2024. Or,
That's
yeah, within, just say within 1 week.
Please.
Okay. Now what follows this? What is the issue?
The Lordship, the
Notice, we notice,
I will
Mr.
take
Sanmati
notice.
accept notice. At his request, re-notify all.
Please, my lord.
also, let's read for a stay of the order, because the penalty notice has been issued, which gets time barred by 31st December.
Your lordship, that is an independent order, my lord. When if
Penalty
order
notice,
is-
there is no order of penalty. Notice which along with the assessment order has been issued. I have requested, I have prayed for a stay of that until the next hearing, Your Lordship.
No. Penalty is need to be deposited before 31st.
Your lordship, yes, my lord, it has to be disposed of, my lord. But your lordship, once the order is passed, my lord, they can file an appeal. They have to come through the channel, my lord. Statutory appeal is
It will be a
provided, my lord.
multiplicity of proceedings, that's all. If the assessment goes, the penalty also goes.
But tell us one thing. Now, this is, let's see, where is the penalty imposed?
Not imposed, Lordship. Notice has been issued. He has to pass an order before this 31st.
So what follows, even if it is passed, will you have a remedy against the assessment order?
Then it will be another proceeding by itself by staying and
Would you not be able to challenge that order in totality, which includes an order of issuing show cause notice on penalty?
no, Lordship, that has to be independently challenged through an appeal.
Which one?
The penalty, if imposed, I will have to file an appeal against that.
Right, but this is at a show cause stage.
This, I'm
What
requesting.
I'm putting it to you is even this show cause which has been issued cannot be a subject matter of the appeal to the commissioner?
No, notice itself cannot be.
It cannot.
It will avoid the multiplicity until the next hearing, that's all.
If they pass an order, then it will be subject matter of an appeal.
Yes, and a new process will start. In the meantime, the Lordships were to hold this assessment is incorrect. Then it will only lead to a multiplicity of.
But
proceedings.
otherwise, against the assessment, you have a remedy of appeal.
Yes, Lordship.
So only to that, but did you challenge the assessment, this order on merits of the
Yes, Lordship,
assessment?
that is where the tribunal held against me. I am before your Lordship, for which Lordships have directed a notice now.
Okay. What do you say?
Well, Lordship, let the order be completed. Let the assessing authority pass the final penalty order, my lord. Afterwards, they can file it appeal before the appellate authority, my lord. Because statutory appeal is there, my lord.
Let's put it this way. If the authority passes an order of penalty, or
Yes,
the
ma'am.
penalty is directed to be paid now on the show cause,
Yes, my lord.
there is a penalty which is imposed,
Yes, my lord.
then he will have a remedy of appeal.
Yes, my lord.
Now that remedy of appeal would be the commissioner.
Yes, my lord. Yes,
And will he be able to in a position to stay that penalty?
Yes, my lord.
No,
They
no,
can file
Lordship.
application for stay, my lord.
No, he
First,
has no
they
power
can
to stay. Commissioner has no power to stay
Your
the.
Lordship,
See, we are only thinking this, why two parallel proceedings?
Yes, precisely. at
Your
that
Lordship,
point.
this is
And
procedure
also
is
that
followed
case-
in all
One minute.
this.
Sanmati, you are clear that he can seek a stay if at all any penalty.
Your
is
Lordship,
imposed.
and if he can approach the assessing officer and seek for stay, my lord.
We will record that submission. Just let's see, let's be clear. This is at a show cause notice stage. It may be imposed, it may not be imposed. Your submission can be, it will be imposed because of the fact that the assessment order went against us, went against you.
Because it is a getting limitation.
But if any penalty is in fact imposed, you have a remedy of appeal even against that penalty before the appellate authority.
Then Lordship, one, it leads to multiplicity of proceeding.
That's the reason it's only to obviate.
Yes,
One proceedings here, one proceedings there. Even if any penalty is imposed, let's assume for a moment. And let's assume for a moment we stay it. Then he can't pass an order of penalty. What we are saying is, at being at a show cause stage, he may pass a penalty, he may not pass a penalty. Let's say the worst situation is he imposes a penalty. Then you can challenge it before the appellate authority. The very same appellate authority which is seized of your challenge against the
Yes,
against the assessment order.
yes, my lord.
yes.
Are there any proceedings at present?
No,
pending?
no, the only proceeding will be before your Lordship.
For us. And is,
Your Lordship, in each and
Nothing will
every
happen
case.
if,
see what he's saying is, one proceedings here,
Yes, my lord.
the other proceedings is against a penalty, he may to have to go to the commissioner. Against that.
Yes,
That means a parallel proceeding,
Parallel
one
proceeding.
there, one here.
yes, my lord.
And maybe see the foundational facts.
Yes,
In that appeal would be the same which
yeah,
are
yes,
pending here.
yes, Lordship.
Getting,
This procedure is followed in all the cases, my lord.
we will look into it, we will look into it. When is that? Ma'am, just have it on Thursday. We'll have it on Thursday. Let's look it on. Just re-notify
Please, my lord.
Thursday.
Much of.
1912.
Lordship, in this case, the office objection is 15. The office objection is certain pages are not legible. That is because Lordship, it is a photocopy of the notice, etc., which was taken as a. So I may be permitted to file a typeset.
Paper copy. The Lanaka, this is the only objection?
This is the only objection.
Lanaka counsel for the appellant states that The objection raised by the registry shall be cleared within 3 weeks from today.
And Lordship, the issue is about, they relied on a third party statement and framed the assessment. I made a request that I may be permitted to cross-examine the third party, because otherwise it's an uncorroborated statement. So far, they have relied on the uncorroborated statement and held against me without affording me a right to cross-examine. The tribunal says it is the discretion and not a right. It is a very strange
But this
finding.
issue is not settled.
This is a settled number of times, Lordship. It is a trade law that unless a statement is subjected to cross-examination, it cannot be relayed. In fact, Lordship, the
Just
courts
please-
have gone to the extent of quashing the order.
They clear the objection.
Much.
Okay. After 3 weeks.
Notice, Lordship.
Now let's see that clear the objection first. Clear the objection.
Much obliged.
Next.
Serial number 16. Yeah, full.
There's a short delay in filing the appeal petition by 19 days.
I have
Who
no,
appears? Mr. Bhatt, you appears?
I have no difficulty with the delay is conducted.
Just say that delay IA 1 of 18. Then application seeking condonation of 19 days delay in filing the appeal. Now the delay is the other appeals.
No,
also?
my lord, the other case is in time, my lord. But what happened, my lord, these are similar in other cases, my lord. What happened, my lord, the assessments are reopened under section 64 on the basis of the income tax report. Now that matters were pending before this honorable tribunal court, my lord. Now the order was passed saying that post these matters after the disposal of the ITAs. That is the order. Now it has been heard that it has been disposed of. I'll look into that and make my submissions. Because ITs have been disposed of on the monetary limits. So what is the effect on the appeals? That has to be decided.
What do you say?
According to me, the revisional order has to be set aside because whole case is on the basis of the income tax report.
That's only a technicality, that's all. The very finding there has not gone.
No, because we succeeded before the tribunal. The department has filed an appeal. Departmental appeal. It is a department appeal before the Honorable High Court. So once a finding is
You succeeded
before the tribunal
on merits.
on merits.
This matter may be posted for admission.
Say
madam.
that,
We'll make
For
submissions.
the reasons stated in the affidavit, and Mr. Bhatt appears for respondent has no objection if the delay is condoned, the delay is condoned, the application is disposed of. List the appeals for hearing on.
My lord, this is the first appeal to the High Court against the order of the additional commissioner. As a procedure, my lord, what you appeals. Admit. And matter may be posted for final hearing because the first
Are the
appeal
substantial questions?
at page number. My lord.
These are common questions in all the appeals?
Yes, my lord. Page number 17, my
Just make a common order. No?
17 and 18, my question.
Just say that admit the following substantial questions of law arises for consideration in these appeals. You said which page?
Page number 17 and 18, my. 19 already, sir. Para 9, question of law. Page 19, page
Just one.
first appeal. STA, 9. STA, okay.
Page 17, para 19. Para 9.
Para 9.
Please just repeat all. That's all. These are common, now we take it common questions.
Yes, ma'am, common question of law in all the cases.
Counsel for the parties to file their submission, written submissions, if any, along with the judgment they want to rely upon. Within 4 weeks, list the appeals on.
10th of February.
Much.
17.
Yes, Mr. Hola.
Correspondent number 1 and 2. ma'am.
Filed an application for early hearing, my lord. The short question, my lord, is whether, my lord, landfill pit amounts to a plant and machinery or not. We are relying upon certain judgments of this honorable court as well as the Supreme Court of India to hold, my lord, that. Anyway, my lord,
File your submissions.
very well.
You say that.
I have no objection.
This is an application. You appear for all?
Correspondent number 1 and 2, my lord.
And what about Mr. Bhatt, you? Don't just show us the.
My lords,
Only two, my lord.
R3,
They are.
1 and 2.
Yeah. Correct.
Additional Commissioner Commercial Taxes, correct.
See, there are two, 1 and 2, you appears advanced.
Yes,
ruling.
and 3 and
have no
4, my lord,
objection.
my learned friend, Mr. Butt appears.
Okay, just say that issue, this is an application seeking early hearing of the petition, full stop, for the reason, very well, for the reason stated in the application and the learner counsel appearing for the respondents have no objection if the petition is heard, comma, the same is allowed and disposed of. Full stop. Counsel for the parties to file their written submissions along with the judgments they want to rely upon within 4 weeks, list on.
3rd February.
Thank you.
Please. My lord, the name, my lord, has to be council name, there's some mistake. That has not been, my lord,
In the-
subsequently they have filed an NOC.
Okay, okay. Just say that Mr. Holal on the senior counsel also states that the name of Mr. Hola, the briefing counsel, be shown instead of Mr. Govindaria Kamath.
Great.
The ability to delete the name of Mr. Govindaraya Kamath from the cause list. Next.
Please.
18.
I appear for the respondent in this case. Last time there was some discrepancy in the describing the cause title. Then I think your lordships have directed.
When was
them
it
to-
listed? Was it listed last week?
Yes.
Just show us.
Well, matter has been settled, my lord.
That has been settled.
Yes.
Okay, okay. So what have you filed? You want to?
Or the amendment application.
That's why your lordship directed us to correct the cause title. There was only a minor discrepancy.
Yeah,
And
we
now
need to-
the matter has been
Show us.
settled in most parties. Filing this. The entire claim has been settled. So there nothing remains to be done.
The appellant proprietor had also expired.
Yes, yes, Bill.
They have been, I think possibly you have seen the amended memo, the corrections which have been made.
Yes, Bill.
On 16 to 22.
Is amended memo parties filed?
Right, please, Your Honor. On 16 to 23, 20.
No, you have the copy, what you have filed?
He has filed.
We have filed.
Yeah.
You have filed it. See, there is still there is some error which I feel. to depict completely, Naga Construction was a proprietorship,
Please,
now represented by 1A, Sarla GN,
please.
Arun Selvakumar, and Guru Sharan
Selvakumar.
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 You should depict their names here,
Please, Your Lordship.
please. Okay.
Oh, since the matter is settled amongst the parties, there's no dispute. Can as well be
No,
accepted.
you're
that,
right. Now, K.N. Rangaswamy was one.
Yes.
K.N. Rangaswamy was represented by 3 LRs, the wife,
Please.
the son, and the daughter.
Please.
Now, the
Oh,
wife
wife
has
is also dead.
Has also passed away, Your Lordship. Wife
She
has
also
also
passed
passed
away.
It also passed away.
and replaced by son and daughter.
Rajiv Rangaswamy and his wife. I'm sorry, his sister. 2A and 2B.
That we have allowed it,
Please, Your Lordship.
that application.
That previous application is allowed, Your Lordship.
No.
Replacing Selva.
Now this has to be allowed.
After the death of the wife. After the death of the wife, have we allowed that application?
No, that has not been allowed. But we have reported the death before this honorable court.
Where is the order bringing these children as party, as legal heirs for the wife also?
Previously, we had made the amendment, Your Lordship.
I know you have made the amendments because of the death of the father,
Yes, Selva Kumar had passed.
not the mother. Getting?
Please.
So, but now what your memo depicts is, they are the LRs of the mother.
Father and mother.
See how you have placed them. So do one thing. You will file along with this an amended, you must file an application also
Please.
for bringing the LRs of the mother also. So what will happen? Appellant, all 3, Arjun Selvakumar, the Sarla GN, Arjun Selvakumar and Guru, show all the 3 names.
Please.
Then comes the respondents.
Please.
Respondents father, 3, 1, 2, 3. Okay. Then under 1, 1A, because 1A, 1B, 1C, na, for the respondents.
Please.
Through the father. Below 1A, possibly you have to show the children as a party.
Please, Your Lordship.
And they will be independently parties as 1B and 1C also.
Please. But with respect to Selva
Please,
Kumar,
the death certificate.
we have previously placed it, Your Lordship.
Mother, place it.
Okay, please, Your Lordship.
We'll have it, bring it on Thursday.
Please.
I'll bring it on Thursday.
Your Lordship, the parties are also present. So they have amicably settled the matter.
What about the others?
The other side parties are also present, Your Lordship.
Who are
On
there?
On Selva Kumar side, we have the son Arjun Selva
What about
Kumar.
the respondent side?
Respondent side,
Respondent is not present today.
the other day he was previously.
He was present in the last date of hearing.
But let them be present here.
They are present.
Now the daughter and the son would be present.
Please.
Appellants would be all those 3, 1A, 1B, 1C.
Please.
We only find 2 of them, not 3 of them.
The mother is.
Sir, mother,
Bring mother also.
GN Sarla.
Please.
Corrected. I hope you are clear now.
Yes, Your Lordship. Please.
Just look into this.
Please.
And then act accordingly.
Please.
We don't want any confusion at a later stage. We'll have it on Thursday.
Please, Your Lordship.
Just say that, just take it back. And just remove it, cut it.
But the daughter has executed a power of attorney in favor of the brother.
But where is that power of attorney?
I have produced already.
Is it on record?
Yes.
Please.
Where did you file it?
Where find it?
At the time of filing.
At the time of filing the wakalat here. Because she expired long back.
Wakalat is.
And they were brought on record and since that his daughter is in Singapore, we filed a power of attorney.
Okay.
In fact, the document has been marked in evidence.
Okay.
There.
Just say at the request of counsel for the appellants, re-notify Thursday.
Your Lordship, one request, the other party Guru is not in the country, he's outside the country. If my Lordship can kindly grant exemption to the mother and Guru. Arjun Selva Kumar is here. The mother and the younger brother is not in the country, they are outside the country. If exemption can be kindly granted.
See, we don't know how, let's see, just show us that. How was the settlement entered? Have they signed it?
Please, Your Lordship.
Just show us.
Before the trial court, when they were here, they have signed it.
Was it before the trial court
Please,
settlement?
Please, Your Lordship.
Trial court has recorded it.
Please, Your Lordship.
Where is the order of the trial court?
We filed the memo, Your Lordship.
Page number 3 minutes, it is filed.
Of
Memo of settlement.
Memo of settlement, yes.
memo filed on behalf of, what is DHR?
Respondent is the DHR before the trial court.
Be very difficult, you know. You put today's date as if they have signed it today. And you say they are not in town.
Your Lordship, Arjun Selva Kumar is here, Your Lordship.
All three.
All the three, it was previously done, Your Lordship.
It is 16/12. Just say that notify, come on Thursday. See, do it accordingly, whatever is done.
Please.
Whenever they have signed it, when they were in town, you need to sign it. Otherwise, simple, there are many objections which will come up later.
Will it be taken up tomorrow, minutes?
No, we want, let them apply their mind. You have a difficulty Thursday.
Yeah, tomorrow I think we can as well finish it.
We don't mind if we can get it,
Please, Your Lordship.
but get it properly
We'll rectify it.
tomorrow.
You bring death certificate also.
Please.
Tomorrow, sir. Tomorrow.
And tomorrow.
17. Okay, number 19. 19, Dilip.
Lord, revenue appeal, my Lord, transfer pricing matter. Lord, page number 9 to 11.
Just say who appears for the response. You appear, ma'am?
I'm permitted to take notice.
We'll admit it. Just say this. You condone the delay.
20 days. delay.
This is an application filed by the appellant seeking condonation of 20 days delay in filing the appeal. The learner counsel for the respondent has no objection if the delay is condoned, they condone and the application is disposed of. Full stop. The admit the following substantial questions of law arises for consideration in this appeal.
1 to 5.
Pages, page 7. Which is,
All different,
yeah.
1 to 5 minutes.
Page 9,
to 11.
1 to 9, page 9 to 11. 5 questions. Full stop. Learner counsel for the appellant submits that the issue of transfer pricing is being considered by a coordinate bench of this court in an appeal remanded back by the Supreme Court, the present appeal be be listed in due course to await the outcome of the said appeal. Full stop. It is ordered accordingly. Next.
Serial number 20. Delay. 20.
Or there's a delay of, my lord, 310 days. There's a delay.
Not this, both the appeals, this.
Let's see that.
Both appeals have to go on monitor limits, but that's subject to what my friend has to say.
Monetary also.
My lord, depending, my lord, whether it's covered under exceptions, my lord, it prima facie, my lord, the amount is less than 2 crores. But I'll have to find out, my lord, whether it's covered under exceptions.
What about 21?
My lord, both. So if my lordship gives us
When will you
liberty
find out?
to, my lord,
My Lordship may close it with liberty to revive in case there's an exception. That's what normally the court.
Can we
Normal-
do that?
please.
Normally do that.
Yes.
Very well.
with
Keep
liberty
my
to.
record, Madhusudan has filed vakalat with him.
Huh. Just say this 2021 separately, just take it separately. Then a counsel for the appellant states that, shall we say appellant?
You know, let it be their submission. my lord.
Mr. Shankar Lana, senior counsel appearing for the appellant states as the
Respondent, my
tax,
lord.
for the respondent states that as the tax effect is less than, tax effect in this appeal is
It's less than 2 crores, my lord.
Less
Circular
than 2
number 9 of 24.
less than 2 crores in view of the circular issued by the Department of Revenue. Department
CBT.
of Revenue, the Central Board of Direct Taxes, dated 17 September 2024. This appeal shall not be maintainable. Then a counsel for the appellant states that it appears that the case, the issue which arises for consideration shall fall in the exceptions carved out in the,
It may. my
You know,
lord.
there's a separate earlier circular.
in the which circular? Where are the exceptions?
I have 24, my lord.
In the exceptions, 5 of 24, what is the date?
Para number 3 of the present circular.
What is the
dated
date, Mr. Shankar?
15/3/24.
In the exceptions carved out in the circular number 5 of 2024 dated 5th of March.
15th March
15
24.
March 2024. Full stop. He states that the appeal be closed, but granting liberty to the revenue in the eventuality the case, the appeal falls within the exceptions as carved out in the circular dated 15th March 2024. Liberty be given to the revenue appellant to revive this appeal.
Maybe मैंने कब का against है मैं
Appeal, it's ordered accordingly, full stop, appeal is closed. Same is in the next 21 also. Thank you. Next.
Right, my lord.
22 adjourn. 23.
Please, my lords, kindly allow me to appear online. This is a departmental appeal.
Yes.
Your Lordship, the delay of 106 days may be condoned, my lord. As far as merits of the case is concerned, my lord, the review petition is pending before the Supreme Court in case of engineering analysis. This may be adjourned for a few weeks.
The
my lord.
case of engineering?
Engineering analysis, my lord.
But one of the review petition has been dismissed, my lords, in the case of G2
Just write
and
it down and
Microsoft.
give it, Mr. Sanmati. Just write it down.
Yes, my lord.
In which case?
Your
You
Lordship,
have any objection on the delay?
Your Lordship, page number 9, my lord.
No, my lords, delay is okay. But as far as the review petition is concerned, in respect of G India Technology and Microsoft, the review petition has been dismissed. My friend is right.
The review petition has been?
Dismissed, my lords.
In connected review petitions are disposed of. But as far as the main petition, that is engineering analysis, it is pending.
Have you heard the submission?
Yes, my lords, I've heard.
He
my
says
friend
it's still
is right.
pending in a.
Yes, my lords, my friend is right to that extent.
Very well. Just say this is an application seeking condonation of 106 days delay in filing the appeal for the reasons stated in the in the affidavit in support of the in support of the where is this application? In support of the application, comma, and the learned counsel for the respondent has no objection. The delay of 106 in filing the appeal is condoned. Mr. Sanmati states that the issue, the appeal be adjourned to await the outcome of a review petition filed by the revenue.
In the case of engineering analysis, your lordship citation, your lordship get it, page number 9, my lord, of the appeal memo, paragraph number 9.
Before the Supreme Court.
Yes, my lord.
In the which page you said?
Page number 9, my lord, paragraph number 9.
Case of Messrs Engineering Analysis Center for Excellence. Reported as 432 ITR, page 471. Say that alternatively AIR 2021 SC 124.
Please.
He is pending consideration before the Supreme Court. If that be so, re-notify the appeal on, give it in February.
24th of February.
Much obliged.
The 24th of February.
The recalling order dated 21/10/2020 dismissed for non-compliance of obligation. The observation complaint.
What do you say, Mr. Bhatt?
No, if my learned friend has complied, I have no problem with restoration.
Yes, February.
A complaint.
Complaint.
Where do you say in your application?
Page number 199, my lord, only one objection, my lord, communication certificate at the time of the filing not produced, my lord. The last date, my lord, I have produced the communication certificate.
Just say this, this is an application seeking recall of order dated 21/10/2024. Whereby this court had dismissed the appeal on the ground of non-prosecution and in default. Mr. Learned Counsel for the appellant, just show us the application, has drawn our attention to the application to content that the objections which were put by the registry has drawn our attention to paragraph where do you say it? Removed?
Pair number 5, my lord. It is submitted the matter was quoted on 12.
Where do you say objections removed?
Page number 199, I put it there, sir.
199?
199. The communication certificate now.
Fresh copy.
States that he has removed the objections as put by the registry. Additionally, he has drawn our attention to paragraph 5 of the affidavit accompanying the application for the reasons of his non-appearance resulting in the dismissal of the appeal for non-prosecution and in default. So for the reasons stated in the application, public affidavit, the order dated 21/10/2024 is recalled. The appeal is restored to its original number. Okay. Application is disposed of. Stop. Now, what is the issue?
My lord, the apparent questioning the order dated, my lord,
List the appeal for hearing.
19/4/23, my lord. And they issued the demand notice on 17/4/2024, my lord.
We will hear it keep it for hearing.
7th January. Serial number 25.
Transfer pricing issues are involved, my lord. I may be permitted to take out notice, my lord.
Is it admitted?
Not yet admitted.
Issue notice. Returnable on.
10th of February. 26.
My lords, I will file a better affidavit, my lords, for the delay. Because my lords, maybe merits on merits also I'll suffer, but my lords, let me first file an affidavit, my lords.
Mr. Tiwari seeks and is allowed 4 weeks to file an additional affidavit to explain the delay of 574 days in filing the appeal.
27. 3rd of February is the date. Serial number 27.
Absolutely, my lord.
Mohan.
There is a delay of 175 days, my lord. I had preferred a review before the respondent, so there was a delay, my lords.
Who appears for this?
We'll take notice for the respondent.
17, you filed a review there
No, I had filed, my lord, that got rejected. That is why there was a delay of 175.
before the
The respondent,
ITAT.
yes, my lord. Your lordship would find that at Annex C, my lord, page 47.
What do you say, Mr. Sanmati?
Delay may be condoned, my lord.
This is an application seeking condonation of 175 days delay for the reasons stated in the affidavit, and Mr. Sanmati has no objection in that regard. The delay is condoned, application disposed of. Then issue notice, Mr. Sanmati accept notice. Gustav lists the appeal for hearing on
3rd of February.
Acknowledgements.
Serial number 28.
28, I may be permitted to take out notice.
issue, a delay of 8 days is condoned, huh, ma'am? Issue notice, returnable on.
10th of February. Serial number 29.
29 also, my lord.
Issue notice, 20 days delay condoned.
10th of February. 30.
Same, ma'am. Here also. 31 also same. 27 and 20 days delay.
10th February. 31.
Same order. That's also 31 fresh, na?
32. Something.
May it please this court.
Yes.
My lords, on the last occasion, your lordships had directed notice and said that your lordships would consider admission on this date. There is a delay of 7 days in filing this appeal. The reasons are to be found at page number 444.
What is the case on merit?
My lords, the appeal relates to the extent to which the assessee is entitled to deduction under section 80 capital P of the Act. The assessee is engaged in the business of extending credit facilities to its members, and it is a cooperative society. Section 80P, subsection 1, confers the benefit of a deduction to cooperative societies, and the extent of that deduction and what will be deducted is laid down in subsection 2. Subsection 2 in clauses A to so and so list the businesses which the cooperative society may carry on. One amongst these businesses in clause A is the business which I am admittedly carrying on, which is of extending credit facilities to my members. If your lordship could take section 80P.
We can hear it now. We'll just pass over.
Your lordship, I have to file my compilation, my lord. Your lordship, I have to file my submissions, my lord. Your lordship, it is not a covered matter, my lord. It has to be heard. It will take some time, my lord. I have not yet filed my submissions, my lord.
Filed and then submissions.
I have filed the written submissions.
We have seen that.
My only submission is admission it may be admitted today. My learned friend may file the submission.
Not admitted, no?
Not yet admitted.
Just say that admit the following substantial questions of law arises for consideration in this appeal. Stop. This would be at pages
15 and 16.
15, 16. Full stop. Counsel for the part, we find that submissions have been filed by the counsel for the appellant. Full stop. Mr. Sanmati appearing for the respondent revenue shall also file submissions along with the judgments he intends to rely upon. Within 4 weeks, re-notify the appeal on.
My lords may condone the delay.
We have not done it. 7 days, sorry. 7 days delay, ma'am, just condone it, huh?
Please.
For the reasons stated in the affidavit, and Mr. Sanmati has no objection. Delays. Next,
17th February.
My lords, 10th of February, if it's convenient.
10th of February, just say.
Oblige.
Next,
Appeal number 33. 33.
Take the appeal, my lords.
this we will hear it today.
Yes, ma'am.
We'll just pass on.
Pass on.
34.
Yes.
So these matters, my lord, I filed my compilation submissions, my lord. My lord, the tribunal,
Your Lordship, I'm seeking some time to file the submissions in this case. I'm appearing for the
So you
respondent.
appear in this?
My lord, the connected matter, there is a,
Oh, there are connected matters.
yes, my lord.
Who appears in the, ma'am, you appear for all the respondents in all the
Your
appeals?
Lordship, I only appear in item 34, 34.3 and 34.5.
The other three I am
The rest
appearing.
you may be appearing.
Yes, yeah, the point, my lord, is the orders are the same as it was served on various partners at that point of time. Everybody has filed an appeal and the issue is not different between the three. Identical 3 years assessment, my friend is also there, I'm also there. Because I'm an erstwhile partner, they were partners during the relevant period when the orders were passed. They were also served on the erstwhile partners. So this,
You file your submission, then Mr. Shankar.
yes, madam.
Your Lordship, I just have one request to make. Your
Yes.
Lordship, in these cases, the quantum appeals were heard by the Honorable Dharwad bench. So my request would be if these matters, these are the penalty appeals which have been filed by the department. So Your Lordship, my request would be if these appeals could be transferred to the Dharwad bench, since the Dharwad bench had heard the quantum appeals.
No, how can that be? No, you make your submissions here, ma'am. This is here.
I will do that, Your Lordship, as Your Lordship
Oh,
said.
my lord, the issue is, my lord, issue is very simple, my lord. The tribunal set aside the order of penalty because on quantum appeal, my lord, tribunal has had granted relief.
Granted the?
Granted relief to the
Yes.
SSC.
On the contrary.
And on quantum appeals, my lord, it was taken up by the revenue before this honorable court. And we succeeded. The matter went up, my lord, before the apex court. There also, my lord, the revenue succeeded. That
No, Your
what was this
Lordship,
honorable-
for the Supreme Court, we had withdrawn. They had not succeeded before the Honorable Supreme
Right.
Court.
In any case, it was not reversed.
Yes, Your Lordship, but there are a few issues which we need to address because
Now, my
the
lord,
quantum
all these
appeal-
matters.
Yes.
Now, my lord, in the light of, my lord, the tribunal having set aside the penalty orders because it had set aside the original order on merits. And now this honorable court, my lord, subsequently having, my lord, confirmed the order of passed by the assessing authority.
submission.
Now it has to go before the tribunal, my lord, for deciding on penalty.
But we need to hear these appeals. The counsel for the part respondents to file their written submissions.
The date may be fixed.
Yeah, we are fixing it. In these appeals, re-notify.
17 to
January.
15 to it's all right. It doesn't really permit.
appeal number 35 adjourned.
15th February, Your Lordship.
Pardon?
17th
15th
February.
February, 17th.
17th February, madam.
Obliged, Your Lordship.
35 adjourned. 36 Shri Anand. 36.
Is this matter connected with 35?
No, man, it's not.
It's separate.
It's a separate. Lord, this is an appeal filed under section 35G of the Central Excise Act, impugning the order passed by the learned stat, which is at page number 93.
Who's been issued in this?
No, sir, notice not.
Huh? Yes, what is the, yes, let's see the order.
My lords, page number 93 is the order starts. And the findings of the learned sestat, my lords, would get it at para number 6 at page number 97.
Well, the issue is during the period of dispute, the period involved here is September 2006 to December 2007. Now, the appellant is a manufacturer of excisable goods, and they also engage in trading activities where they import goods and sell it in India. So it's a complete trading activity. Now, they are also an LTU assessee, that is large taxpayer unit assessee, and they are registered coming under the Bangalore LTU jurisdiction. But it's the issue involved in here is the interpretation of send-back credit rules. That is more to be more particular, Rule 6, Sub-Rule 5 of the send-back credit rules. Well, what had happened is that the appellant being engaged in manufacture of dutiable excisable goods, they are entitled for the benefit of send-back credit, which is now called as input tax credit under the GST law, wherein the eligible central excise duties and service tax paid on inputs and input services, they are entitled to take the send-back credit and set off against the duty payable on the final product. Now, here what had happened, my lords, during the period of dispute, that is September 06 to December 07, the appellant received input service, that is import of services rendered by their foreign counterpart abroad, and that classification of that service in terms of the service tax law was under management consultancy service, which is classifiable under section 65(105) clause R of the Finance Act of 1994. They paid the discharge the service tax and a reverse charge mechanism, that is as an importer of service, as a recipient of service. And since this input service, qualifies as an input service, which there is no dispute in terms of Rule 2L of the send-back credit rules, they availed the send-back credit benefit of entire service tax paid of 1,56,29,750. Now, what had happened is that this particular service, input service, that is management consultancy service, it's a common input services which is relatable to both their manufacturing activity and also for their trading activity.
But how do you overcome Lalli automobiles?
My lords, what the tribunal has done is that our entire case was twofold. One is that during the relevant period of dispute, that is September 06 to December 07, the trading activity was never construed by the send-back credit rules as an exempted goods or an exempted services. That amendment came to be made by the government only with effect from 1/4/2011. Now, what happened 1/4/2011 was that the government amended the definition of exempted services in Rule 2E of the send-back credit rules of 2004. An explanation was inserted. They say that trading activity shall be deemed to be exempted services. Now, having done that, the question before the tribunal was that whether during the period of dispute, which was much earlier to the amendment, whether it would have retrospective amendment or prospective amendment, number one. Insofar as that issue is concerned, what the learned tribunal finds is that, see, look, there is a judgment of the Honorable Delhi High Court in Lalli Automobiles, and also by the Honorable Madras High Court in Ruchika Interlinks case, where the Madras High Court holds that this amendment, which is effective from 1/4/2011, it will have a retrospective effect. So therefore, it has to be construed accordingly. Now, on that score, for the time being, I'm not onto that before the learned tribunal. Now, the second plea which I took, alternative plea, was that if that be so, that the amendment that is trading is construed as an exempted services, and the rigors of Rule 6 has to be applied to me, then there is a sub-rule 5 of Rule 6, which is categorical, which is a non-obstante clause. For my lord's consideration, I've enclosed the extract of the relevant rule. If my lords kindly please come to page 28 of my appeal memorandum. Annexure A, I've just given the extract of Rule 6. Because here is a case where these management consultancy services, which is the bone of contention, that's an input services, that is not exclusively used for trading activity. That's an admitted fact. So it is used for both my dutiable activity and also for the trading activity. So even if it is assumed to be an exempted services, I mean, part of it has been used for exempted services by virtue of this retrospective amendment as held by the Madras High Court, then the provisions of Rule 6, Sub-Rule 5, that Sub-Rule 5, my lords, will get it at page number 30 of my appeal memorandum.
Now, have you paid this demand?
No, it has not been paid. In fact, it has been reversed. I'm sorry. I have reversed it under protest, and the protest has been removed by the lower authority, that is by the adjudicating authority.
Reverse means?
Proportionately, what I did was that pursuant to audit conducted of my records, so the department made an audit observation saying that, see, look, to the extent which is attributable to this trading activity, you're not supposed to take the credit, so reverse it. So under protest, I reversed it because my contention from the beginning was that by virtue of rule 6.5, I'm entitled for the Senmat credit even on this portion, even if it has been used for trading activity.
How much was inadmissible credit, Senmat credit?
79 lakhs.
So this amount you have reversed it.
Yes,
So you reversed it in the sense that maybe under protest.
yes,
So whatever the benefit you sought to get it, that being an exemption
Yes.
or admissible,
yes,
that has been reversed.
yes.
So what is now payable?
Nothing, my lords, because
Nothing.
I paid it also along with the interest. And of course, the
No, but what about the demand of 15 lakhs odd?
that has been set aside by the tribunal itself.
To that extent, it's set aside.
Yes. For a moment, my lords, kindly come to page 30.
That has been set aside.
Yes.
But after this Delhi High Court and Madras, they
Because, yes, my humble submission is that both the Honorable Delhi High Court as well as Madras High Court, they were only onto this, whether this amendment effective from was retrospective or prospective, that was the issue. Now, the interpretation of Rule 6, Sub-Rule 5, which is critical in my case, was never considered or never an issue before the Honorable High Court. On the contrary,
let's see that you said page 20.
Page 30 is the Sub-Rule 5 of Rule 6.
13.
30.
30.
Yes.
Notwithstanding anything contained.
Yes, my lords. Can I just read it out?
Shall be allowed unless a service is exclusively in or.
My input service comes under R, that is management consultancy, which is one of the specified input
It's
services.
there.
Yes.
It's there. Let's read it. Notwithstanding anything contained in sub-rules 1, 2, 3.
Yes.
Credit of the whole of service tax paid on taxable
Taxable service.
services as specified in this
Subclause.
of section 65 shall be allowed unless a service is used
Exclusively. So that is very critical. So unless it is used exclusively, because this is an exception which was called out. So in respect of these 17 specified.
It's simple, this, whatever you are importing
Yes.
must be used for exclusively for the exempted goods.
Yes. If
Simple.
that be the case, then I may buy that. I'm not entitled.
Will be entitled to the benefit. You will be entitled for exemption. How would you construe it?
No, if it is, if any of these specified, it's a non-obstante clause, it overrides sub-rule 1, sub-rule 2, sub-rule 3. So in respect of these 17 specified services, input services, if it falls under that, then unless those input services, if it is used only exclusively for exempted services, then I'm not entitled for taking the Senmat credit. If it is used partly, then there is no question. So I'm entitled for the whole of the Senmat credit. So this critical aspect has not been appreciated in by the learned tribunal. And in fact, the Delhi High Court and also Madras High Court does not consider this aspect at all. On the contrary, my lords, we also place reliance of this Honorable High Court in the case of MetLife, which is also recorded in that, but that has been completely ignored.
We'll issue notice, let them come.
It may kindly be admitted, my lords. In fact, we have raised the substantial question of law at page number, my lord's consideration at page number 8.
Let them come, we'll issue notice.
Step.
Issue notice. Returnable law.
10th February.
Grateful.
Thirty-seven urgent, 38. Raviraj. 38.
My lord, the respondent is a the educational institution which was granted registration under section 12A. My lord, subsequent to granting of registration, a search came to be conducted, my lord, under section 132. From the incriminating materials, it was found that funds were diverted for the use of the.
Issued on this. Just say issue notice. Returnable law.
17 to 39.
Same, 39 and 40.
Issue notice.
17 to 40.
39 and 40 are same. No, rather all three, 38,
Lord,
39, 40.
Please, three matters, my lord. My lordship may consider admitting, my lord, because there is a pure question of law.
Let them come. We'll do it. 38, 39, 40.
41. 41.
Is it Amazon or Amazon?
Amazon. It's Amazon. This matter, my lord, transfer pricing. After the passing of the order, my lord, 263, a revision came to be exercised. My lord,
Issue notice. Just say issue notice. Returnable on.
17 to 42. Parthasarathi. 42.
The question of law is in page number 12 and 13, your lordship, where we are challenging the disallowance of the deduction in section 43B, your lordship, by its subsequent amendment of section 3615A of the Finance Act 2021, where the adjustment was made by this respondent, your lordship, by issuing order under section 143(1), where is the adjustment.
Here's for the revenue here.
Arvind Chauhan.
My lord, I appear for respondent in this matter, my lord.
Okay.
My lord, I appear for respondent in this matter.
Okay, okay.
I'll take notice.
Just say issue notice, so and so accept notice. Returnable on. You have the copy of the appeal paper book?
No, my lord, I'll collect the copy from my.
The
Let a
first
copy-
posting I'll provide.
Let a copy of the appeal paper book be given to the counsel for the respondent.
17 to 43.
Much obliged.
43.
Submissions have not come.
my lord, the issue is, my lord, an order came to be passed because the SSE respondent had failed to make the payment of advance tax. A contention was taken up that the SSE had merged with another company. And my lord, the consequences of which, my lord, ultimately tax may not, when the assessment is completed, there may not be a tax due at all. No, my lord, let them file the copy of the order of assessment because assessments are done in Delhi, my lord. It could have a
Being led
bearing
by
on.
Mr. Sachit Jolly, my lord, senior advocate.
Where is he?
I can see him, he's logged in.
Because the issue may arise, may not arise at all, because consequent to the final order passed by the assessing authority of the amalgamated company.
Okay.
Because amalgamating company had failed to make the payment.
Okay. Yes. Where is he?
Let them file the order of assessment, my lord, it would.
You file your order of assessment?
I'll do that, my lord, I'll take it.
Just say that the counsel for the appellant shall file. The order of assessment would be of which company? Of the
Amalgamated company.
Amalgamated.
Sorry, amalgamated company.
Say that the counsel for the appellant shall file the order of assessment for the year. Of the
Lord, I'll pass.
amalgamated company of the year, assessment year.
Two 2017-18.
17 and 18. Within 4 weeks with a copy to the counsel for the respondents. Then you look into this.
Please.
You
Well, my
notify.
difficulty, my lord, assessments are completed in Delhi office.
That we will see. That we will see it. With the other companies there. Why it was done in Delhi?
That is also in Delhi.
That's all. Even okay.
17th February.
My lord, the interim order may kindly be extended.
Interim order, if any, is extended till the next date of it.
7 to
44 urgent, 45, delete. 45.
The respondent might take some time to file
Uh,
objections to the
My
application.
lords, I'm so sorry, my lords. I
Yeah,
missed
Mr.
out.
Jolly, we
I'm
have
so sorry.
adjourned it.
Please, my lord.
the counsel for the revenue, he wanted to, you to place on record the order of assessment of the amalgamated company.
Amalgamate.
I believe we've already filed that, but I will still do that. I'll serve a copy on my learned friend. There's no difficulty.
Just look into it.
I will do that. I have kept it for, I'm so sorry.
We have
Which
given you
date,
the date. We have given the date.
17th February, sir.
I'm so grateful, Malad. I'll make arrangements. I'll serve an advance copy on my learned friend.
Yes. Next.
I'm so grateful.
45, believe.
Writ appeal file, Milord, there's a delay.
How do you explain the delay, Mr.? Yes, let's see your application for contribution. Why otherwise so much delay takes place? 324 days. 326.
Milord, the learned single judge, Milord.
What? Okay, this is, let's see. What do you say? What is the submission?
Administrative delay, Milord. Administrative reasons.
What is on merit?
Merit, Milord. After the completion of assessment, Milord, the records revealed that a part of payment made to contractors, Milord, TDS had not been done. Out of payment of 74 crores, TDS was made only to the extent of 35 crores. Then 148 notice came to be issued. Then, Milord, learned single judge came to the conclusion that, Milord, the materials were already there. So it's only a change of opinion. Now, Milord, the revenue is relying upon, Milord, explanation 1 to 147, which says, Milord, any evidence which could have been, Milord, with the due diligence, if it could have been discovered by the officer, Milord, still it would come under 148. Milord, reasons could be recorded.
Is the material discovered?
Milord, TDS is not done, Milord.
Let's see, where does the learned single judge say?
Milord, the reasons recorded is in 201. Page
So
number.
let's see the finding of the learned judge.
Please, that's in 42. Page number 42.
Yes.
Lord, para 17, he refers to the judgment of Kelvin et al. India. Lord, it is settled by the decision of the Honorable Apex Court with the decision of Commissioner of Income Tax versus Kelvin et al. India Limited that mere change of opinion cannot by itself be a reason for reopening the assessment, as it would amount to the assessing authority reviewing the assessment. The change of opinion must be applied as a built-in check to prevent such review, and the assessing authority can reopen the assessment only when there is tangible material to conclude that there is escapement of income from assessment. So, Milord, the reasons are in, Milord, page 201. Basis for forming reason to believe and details of escapement of income. Milord, whole case will not.
Objection on the delay.
I'd like to file my objection. Unfortunately, I don't have the copy of the application also.
326 is a normal delay for a matters. Okay, let objections to the IA 2 of 23 be filed within 4 weeks. Okay, re-notify the appeal on
You know, whole case is whether it amounts to change of opinion or.
We'll look into that, but you have to cross this hurdle of delay.
10th of February. Seal number 46. Government advocate.
Appear for the respondent in this case.
My appeal. Slightly voluminous papers have been provided to me only this morning, my lord. Appear to be two issues, whether limitation and whether the assessee ought to have been given a right to cross-examination. I'll file my written submissions if your lordships permit. Maybe had.
No, but tell us on what is on right to cross-examination. What is the otherwise the procedure followed?
My lord, a search and seizure operation is, a search inspection is conducted, my lords. Multiple orders, multiple opportunities of being heard are given. He then files a writ petition, and all orders are set aside on two grounds. One, so far as limitation is concerned, and two, on right to cross-examination.
But tell us one thing, what is the material you rely upon? Something, right of cross-examination, possibly his argument would be that what is being decided is based on a material without putting it to him.
My lords.
Something like that, what is being.
If I pick up documents during an inspection, pick up records during an inspection, a report is drawn up in presence of the assessee or the assessee's representative. If I rely on that, my lords, where is the question of cross-examination on those matters?
And who is from where did you get that material?
From the assessee's stores, my lord. From the assessee's stores.
From the assessee's place only.
My lords. Lords, where there is an opinion given or a statement given which incriminates the assessee, your lordships, I will have to concede that there is a right of cross-examination. Any incriminating statement, any incriminating.
It is not that type. It is not that case.
It's an inspection
on a material recovered from his place.
Yes.
He's nodding his head.
My lords, because there are two witnesses in the proceedings, which are essentially the vendors who have allegedly supplied materials to the SSC.
Whose statement was recorded?
Please, my lords. And the right of cross-examination was invoked in the context of one of those suppliers. And second of all, my lords, what happened was that against the initial order of reassessment, the matter traveled all the way to the Appellate Tribunal, was remanded back for fresh de novo adjudication in the year 2012 or 2013. Till 2018, my lords, no order was passed, because of which the issue of limitation came up, on grounds of which the single bench was pleased to set aside the order. Whenever I have absolutely no objection for the plea for adjournment, but the issue, my lord, is that the tax period goes back to 2005-6.
On limitation.
My lords.
Please, my lords.
Was it on a remand, Mr. Bhatt?
Please, my lords.
No, if that be so, then whatever, how much is the period within which the reassessment or assessment need to be taken? Is it 7 years or 5 years?
There are varying periods, my lords, because the law kept changing. For example, my lords, in so far as the proceedings related to April 2006 is concerned, sorry, my apologies, from April 2006 to October 2009 is concerned, insofar as the number of days spent in appeal is concerned, is 783 days, my lords. Thereafter, if the date for limitation is considered, in page number 49, a detailed tabular column has been provided. In that tabular column.
But this would not be covered by the judgment on the limitation based on Jaipuria, all those.
My lords. I'll look into it because, my lords, what happens is your lordship's judgment, I don't think has been released.
Pardon?
I don't think your lordship's judgment has been released.
We'll check up.
Because your lordships had indicated in open court you would allow that appeal.
Yeah, we have allowed it. That's basically Jaipuria.
Yes.
Then even the assessment order, the limitation would be from the date, from the date.
Assessment period.
Assessment period.
After subtracting.
Whatever is earlier, what has been said. The assessment order.
Yes.
Or the assessment period, whichever is earlier.
Please, my lord. Yes. After subtracting the 700 or after adding the 783 days, which has been spent in appeal and review.
The delay ranges, my lords, anywhere between 590.
That be so. Even if you add this 780, and from that, and it must relate back.
Yes.
Please, my lords.
From that date, it will be there. If it is beyond 7 years or whatever is the period, then it would be hit by limitation.
Yes.
We look into it, we will also check up.
Yes, I will tabulate it, my lord, and therefore, like in the previous matter, if I'm not able to join issue, I will, my lord, make
No,
that
you
submission.
see,
But I will,
you look into the judgment, you also look into.
Please, my
it.
lord.
We will
I'll
check
look.
up also. It's
Please,
not-
my lord.
Just say that re-notify this appeal on. Just give it in second or third week of January if it is fine.
16th ಆದ್ಮೇಲೆ ಕೊಡ್ತೀರಾ?
Give it after 16.
16th January.
Tax
Tax is 20th January.
20th. Much of it.
20th January.
Grateful, my lord.
What is the appeal number, Mr. Bhatt? You remember that appeal number?
I'll have it in my notes. I don't.
Just check up. Give it to the court office.
I'll do that. Grateful, my lord.
Appeal number 47, Shri Tirumala.
Lords, this matter, the issue is whether under the assessing officer has got jurisdiction under section 148 to reopen the matter. Lordship, we require some time, and apart from that, the submission is that if your lordship is kind enough to condone the delay, it can be taken up for arguments.
Your lordship, senior advocate Mr. Ajay Vora will be appearing in the matter. He has asked her.
What do you say on delay, ma'am?
34 days delay.
34 days delay.
Your lordship, if we be allowed an opportunity to file an objection to this.
34 days is nothing much. We'll allow this 34 days delay.
Your lordship, only then we can postpone it for the senior advocate to argue the matter.
That we will do it. That's only appeal, only on an appeal. It's all right. Then we will have it on the next day. Let the council be here.
I request the formality of delay condoning can be finished.
Will that make any difference? Should not.
No, then it will be listed only for that reason. That's why, because even ASG may come for the
This
hearing.
is an application seeking condonation of 34 days delay in filing the appeal. In both the appeals, for the reasons stated in the application. You have any serious issue on this? On the delay of 34 days?
We just feel, your lordship, it's a negligence on the part of the revenue. It's negligence. The delay is due to negligence on the part.
Can't be construed as a negligence. Something you're running in 4 figures, then possibly we would look into. For the reasons stated in the application, in the affidavit accompanied by, just give that affidavit, ma'am. The delay of 34 days in filing the appeal. Appeals are condoned. In both the appeals is condoned. The applications disposed of, list the appeals for hearing on.
10 to.
Your lordship, if we can have a date on 6th of February, if that is possible.
Just check up, ma'am, 6th February.
Mondays only are fixed for date
Sir,
hearing.
6th of February, is Thursday, sir.
Oh, it's not Thursday, ma'am, we'll give you Monday, ma'am.
3rd February, your lordship.
Monday.
3rd February.
Right, your lordship.
Perfect.
48.
I'm appearing for the petitioner, your lordship. Your lord, I'm for the petitioner. Lordship, I've challenged the order of the appellate authority, your lordship. Appellate authority rejects my appeal on the issue of limitation, your lordship. The order of the appellate authority, your lordship, is at Annexure K, page 561, your lordship. Lordship, the facts leading to this order, your lordship, is that I filed an application before the advanced ruling authority on 25/4/2018, your lordship, seeking a ruling on a certain issue.
Against advanced ruling only writ, there is no appellate jurisdiction.
Your lordship, there is an appellate jurisdiction.
Then
Your lordship, I filed an application. The order was passed on 25/7/2019. That is the order of the authority for advanced ruling. I filed a rectification of mistake application, your lordship, on 27/9/2019. Your lordship, the statute permit me to file a rectification application, your lordship, is that section 102, your lordship.
let's see the impugned order.
Annexure K, your lordship, at that page 561.
551.
561, your lordship.
561.
Yes. The finding, your lordship, is at page here. The discussion starts from page 567, your lordship. On two grounds, the appellate authority rejects my appeal. I file a rectification application. The section provides me to file a rectification. I filed the rectification within 2 months of the order being passed by the authority for advance ruling. And that rectification order got to be passed on 2/2/2021. After passing the rectification order, your lordship, I file an appeal before the appellate authority.
Which is the appeal?
That is within 45 days, your lordship. I file an appeal on 7/11/2020.
That's basically for rectification.
Rectification order was, sorry, my lord, rectification order was passed on 11/9/2020, your lordship, ROM order.
Where is that order?
It's at Annexure D, your lordship, but it's at Annexure
272?
Annexure G, your lordship, at page 292, your lordship.
Now your application was allowed?
My RM application was not allowed.
Not allowed.
On the finding, your lordship, that I'm not provided.
Then you file and is there any remedy you availed after this rectification?
I filed an appeal, your lordship, before the appellate authority. Now the appellate authority states, your lordship, I would read the statutory provision, your lordship. Section 102 of the CGST Act, your lordship.
Yes, shows that. Which section?
102, your lordship. Rectification of advance ruling. Shall I read, your lordship? The authority or the appellate authority.
Yes, sir.
Yes.
Yes.
The authority or the appellate authority or the national appellate authority may amend any order passed by it under section 98 or section 101 or section 101C respectively, so as to rectify any error apparent on the face of the record. If such error is noticed by the authority or the appellate authority or the national appellate authority or in its own accord, or is brought to its notice by the concerned officer, the jurisdictional officer, the applicant. Your lordship, I am the applicant. When the order was passed by the authority for advance ruling, within 2 months, I filed an application seeking rectification on the ground that the equivalent, the coordinate bench passes a divergent view compared to the view passed in my order. So I sought for a rectification of that order.
Will that be a rectification application? That's basically a challenge on merit.
Your lordship, I filed a rectification application on 102. The authority considers that application and passes an order at a later date. After passing that order, your lordship, I file an appeal under section 100 of the CGST Act.
100?
Of the CGST Act,
Yes.
appeal to appellate authority.
Okay.
Section 101, your lordship.
Tell us one thing, what is the limitation for appeal?
Your lordship, it is 30 days from the date of passing the order.
Now, let's test it. The initial order of the authority,
yes,
which is at page 560 or so. What is the date of that order?
It was passed on 25/7/2019, the first order of the
25/7/2019.
Yes, your lordship.
That's right. Now you have 30 days. You have 30 days to file an appeal?
I have 30 days to file an appeal, your lordship, from the date of the order of the authority.
Very good. So let's take it on 25/9/2019, you got the order?
I have filed a rectification application.
We'll
Yes.
just come to rectification.
Yes.
Now, rectification application was filed when?
Your lordship, it was filed on 11/9, sorry, lordship. It was filed on 27/9/2019, 2 months from the date of passing of the order by the
Now,
authority.
it is otherwise 30 days. You filed beyond that period.
Your lordship, but section 100, your lordship, provides me a time of 6 months to file a rectification application. Section 100 of the Act, Your
Oh,
Lordship.
it says 6 months.
Section 102, Your Lordship.
102 says.
102 says 6 months from the date. So I
But
filed
you-
within 2 months.
You are within limitation.
I'm within limitation there as far as my rectification application goes.
Okay. Now.
Then the authority was supposed to pass an order within 6 months, passes an order, RM order on 11/9/2020. The moment the authority passes an order, I filed an appeal within 2 months with a condonation of delay of 20 days. Because the order was passed by the authority.
Let's see section 100.
Yes, Your Lord. Section 100, the concerned officer, the jurisdictional officer or an applicant aggrieved by any advance ruling pronounced under subsection 4 of section 98 may appeal to the appellate authority. Every appeal under this section shall be filed within a period of 30 days from the date on which the ruling sought to be appealed against is communicated to the concerned officer, the jurisdictional officer, and the applicant. Your Lordship, if I consider 30 days here, section 102 becomes what yours?
Right, very interesting. It's an
Yes.
interplay between 100 and 101.
Yes, Your Lord.
Now, let's see first the ground on which he has rejected. He said so it's beyond limitation. Does he say so beyond limitation? The impugned order?
Yes, Your Lord.
On
On
what
2
ground?
grounds.
Huh.
One, the impugned order says that the time limit has to be invariably computed from the date of the order being passed by the authority for advance ruling.
That
And
is-
second, the ROM order being passed, it's an administrative order and it is not in the it is not in the jurisdiction of a quasi-judicial jurisdiction that the ROM order is passed. So on 2 grounds, the appellate authority says that I will take the time limit from the date of the order being passed and not from the date of the ROM order being passed.
Now we are putting it to you. Prima facie.
Yes.
Now, what is the ground on which rectification can be filed if there is an error apparent on the face of it?
Yes, Your Lord.
Surely there is no error apparent on the face of it.
My Lordship, that was the error where I have pointed out to the authority for advance ruling was the divergent view of the same coordinate bench
That's on
was
merit.
passed
That's on merit.
prior to that. Your Lordship, that according to me was an error of law, where I made an application before the authority. If the authority could consider that order which has been passed by the same jurisdictional.
It's only jurisdiction, not by the same officer?
It is by the same officer.
By the same?
One by the same officer. Yes, Your Lordship. And the officer, Your Lordship, the ROM order does not say that I don't have jurisdiction. It says that certain documentary evidences were not produced. So for that reason, ROM application gets to be dismissed.
So,
because there is no, the authority for advance ruling doesn't say there's absolutely no jurisdiction at all to consider your ROM application.
now, let's see your rectification application. Let's see the finding first in the impugned order.
Yes, Your Lordship. The finding starts from page 567, Your Lordship. The relevant finding, Your Lordship, is at paragraph 15 at page 569, 14 and 15, Your Lordship.
Yes.
Paragraph 14.
14.
Now let us set out the facts in this case leading to the instant appeal before us. The appellant filed an application for advance ruling on 25/4/2018 before the authority in terms of section 97 of the CGST Act, seeking a ruling on the question relating to applicability of tax on the works executed under joint development agreement with a landowner, where the work commenced before GST implementation and continued even after GST was implemented. The said application was admitted by the authority under section 98. The question raised in the application was examined and a ruling was pronounced in terms of section 98(4). On 25th July 2019, with a order date number so-and-so, dated so-and-so. On 27/9/2019, the appellant made an application to the authority for rectification of mistake. In the advance ruling dated 25/7/2019, the RM application was filed on the ground that the authority had given a different ruling in their case when compared to the ruling given with a order number so-and-so, dated 30/11/2018. In the case of advance ruling application filed by Mrs. Enforced Infrastructure, where the facts and circumstances in both the cases were the same. This RM application was not admitted by the lower authority and was rejected with an order dated 11/9/2020 in terms of section 98(2) of the said act for the reason that the lower authority had considered all the submissions and facts and pronounced the ruling on all questions of the applicant, and there was no error, mistake which was apparent on record. It is again this rejection of ROM with an order dated 11/9/2020 that this appeal has been filed before us. The reading of the above provision of law makes it clear that an appeal can be filed before the appellate authority only against an advance ruling pronounced in terms of section 98(4). In the case, the ruling pronounced in terms of section 98(4 is the advance ruling order dated 25/7/2019, an appeal is maintainable only against the said order dated 25/7/2019 within the statutory period of 30 days from the date of communication of the said order. However, no appeal has been filed before us against the advance ruling dated 25/7/2019. The appellant contended that they had filed for a rectification of mistake in the advance ruling dated 25/7/19, and hence, when a matter is pending for rectification, the remedy of filing appeal accrues from the date of completion of such rectification proceedings. In this connection, the appellant had relied on the Allahabad High Court order in the case of utility equipment. We have gone through the said decision. We find that the decision was rendered in the context of the UP Trade Tax Act, where an assessment order was passed in the case of the petitioner by mentioning a wrong name. The petitioner had made an application for rectification of mistake in the name, and the same was allowed. The Honorable High Court held that in such circumstances, the time limitation for filing an appeal against the assessment orders could be reckoned only after the service of the amended order rectifying the name of the petitioner. We cannot apply the same ratio to the appeal before us. In this context of the GST law, the scope and ambit of a proceeding for appeal against an advance ruling order in terms of section 100 of the CGST Act is distinct and different from the proceeding for rectification of an advance ruling order. The jurisdiction for rectification of advance ruling order for mistake apparent on record is conferred on the lower authority, whereas the appellate jurisdiction lies with the appellate authority for advance ruling and is clearly limited to appeals against the advance ruling order. Both jurisdictions are distinct and conferred on different authorities. It is therefore an incorrect interpretation that an appeal can be filed only after the order in respect of rectification of mistake application is passed. The procedure for rectification of mistake is akin to an administrative function, wherein mistakes which are apparent on record are corrected by the authority which passed the order. On the other hand, the proceeding in appeal in terms of section 100 of the CGST Act are judicial proceedings, wherein the type of order which can be appealed against and the time period for filing the appeals are clearly laid down. Therefore, we hold that the order passed by the lower authority rejecting the ROM application is not an order which can be appealed before us. I have not appealed the order of the ROM. I have appealed against the original order, but I have a provision for rectification for whatever.
See,
But it is not an administrative order in any case.
You may agree, but they could not file an appeal within 30 days.
Yes.
File an application for rectification, whatever it's worth. May not be an error apparent on the face, but they will still file it under the heading rectification. Just 1 minute. There is no error.
Hypothetically, yes, Your Lord.
Then that is decided. They say, now this is going to give me cause of action of 30 days to file an appeal.
Yes, Your Lord.
Possibly that may happen.
Yes, Your Lordship. I'm not denying.
And it appears the reasoning is only on the slide. There was no error apparent.
Lordship, my contention, Your Lordship, is that there was a reason enough for me to file an application because there was a divergent view of the same bench.
Right.
Correct.
See, a divergent view is a substantive pronouncement on that view or on that issue by the court. It's nothing error. What were we talking of error apparent is some mathematical mistake.
I agree, Your Lordship.
All those things we are contemplating.
Yes,
not on a substantive, on a finding, which is a substantive finding, saying that this is my conclusion. Maybe overlooking an earlier judgment, but that would not be an error apparent.
My only contention before Your Lordship is that whether the appellate authority could have sat in a judgment on my ROM application, because ROM is filed rightly with the jurisdiction being available on me. If that jurisdiction is taken over, presuming that I filed the ROM application correctly, but the authority for advance ruling rejects it, then my appeal will render OTOs, when I will be left with no remedy. Both ways are possible, Your Lordship. If the authority says that even though you filed an application for rectification, I'm not rectifying it because he has 6 months time for
See,
rectification.
the only ground you can argue is this. Error apparent,
Yes, Your Lord.
it's in the nature of a review.
Yes, Your Lord.
A review is maintainable if an earlier judgment has been overlooked. Then the subsequent judgment, possibly, it's a per inquiry. You can argue. Either I am coming, though the nomenclature of 101 is not review in that sense, it's only in the nomenclature of a rectification. But in effect, when there is an error, what is the ground for review? There is an error apparent on the face of it. That's the ground. So you have overlooked that particular judgment on the same issue, on an identical issue, and come to this conclusion possibly against me. And I have come only to show you that this is a judgment which you have given yourself, and this need to be corrected.
Your Lordship, say otherwise the whole provision will give us such a contradictory meaning that I can't make an application for rectification at all because 6 months is the time limit which is provided.
See, that's the catch.
Yes, Your Lord.
And there can be an issue. There can be instances where this can be bypassed, knowing well the limitation period for filing an appeal has gone,
Lord, it works both ways.
has expired, right?
Yes.
Has expired. But they must also reconcile.
Yes,
But this judgment of the Supreme Court, which has been referred to, if you see that judgment,
High
possibly
Court has
that
been
answers
referred.
the question.
The Karnataka High Court has been referred. The Justice Ravindra's order.
Ashu Engineers Plastics.
Yes, Your Lordship. There is no merger of in rectification. There is no merger, but both works. That's what the
You
court
read para 16.
Yes, Your Lordship. The appellant has also relied on Supreme Court decision in the case of Kundan Lal Sri Krishna versus Commissioner.
And also
the decision of the Income Tax Appellate Tribunal in the case of Ashu Engineers and Plastic Private Limited to support their argument that even though the rectification application got rejected by the authority, the advance ruling order passed under 98.4 is admissible for appeal and the time limitation shall be calculated from the date of the rectification order and not from the date of the original order.
So it should be from rectification.
Yes,
They are
Your
not.
There is a delay of 20 days. So that delay can be condoned by the appellate authority. I'm on substantive law. It cannot be interpreted in such a technical manner to defeat the. I've gone with a good intention. I've never gone with a intention of running away from the law.
In a case of bona fide is fine.
Yes, Your Lord.
In a case of mala fide,
that is something which
it is susceptible.
this has to be reconciled, Your Lordship, because the new law, because it's come in 2017.
It is susceptible to be taken advantage of, this provision.
Both
Interplay between 100 and 101. He knows I am barred by time. Okay, let me file a rectification because I have 6 months time to file a rectification.
I have not done that here because I've.
You do not have. We are saying a given case.
Yes, Your Lord. That's possible, Your Lord. I am not denying that at all.
The notice has been issued on this. Issue notice.
TF Annexure K. TF Annexure K still said.
Yeah, what?
Annexure K, Your Lordship, because it operates against me because under section 103, this order operates against all the adjudicating authorities.
We will see. We have to decide the issue.
Obliged.
Are there any appeals which are following, any rectifications which are following now?
They have already been filed there because all the issue pertaining to this, Your Lordship. The law is clear. Later, at the later period,
you can argue in a given case, the rectification was actually allowed. But you are still aggrieved. Like this, let's put it. Main order, we are just giving a hypothetical example. Imposes a liability of 100 rupees. Just observe. You are aggrieved by that. Your case is, I am not entitled to any penalty at all. That's hypothetical. You go file a rectification that is allowed to the extent of 50 rupees. You're still agreed by 50?
Yes.
Then what will you do? Your 30 days have expired for filing the appeal. Rectification decided. Then going by this logic, you were to file within 30 days. But this order passed, reducing it to 50% will not give you a cause or will be barred by time because you could not able to file.
Exactly, Lord. That's what the way it's been passed. It said ROM applications are not considered irrespective of that one. It was read here in 98.4. That could be
10th February.
This is CGST.
Yes, Your Lord. Hem Kumar.
Is this the local act or under the
CGST Act, Your
CGST
Lordship.
Act?
CGST
Mr.
Act. The Karnataka Appellate Authority is constituted under the SGST Act, Your Lordship.
Oh,
Appellate Authority for
but
Advanced.
this would not be your, this thing?
This is under,
Issues pertains to CGST as well as KGST.
That's right.
Appellate authority is constituted under the KGST Act,
Local, in the state act.
State Act.
Okay, issue notice, returnable.
union, you can take.
Union
Yes,
is
Your
one.
Lord.
Mr.
Union and.
I take Malone.
So
Notice for-
Neil will give just
Respond.
for accept
2 and
notice
3
for
of the state
respondent number
authority.
1. See, to be, I don't know, CGST may also come in
Yes, yes. CGST.
on a larger issue. And if this is the common provision across,
Yes.
then it need to be looked into.
Like,
But tell us one thing, under 100, there is no power to condone?
under 100, there is no,
Power to condone,
no, Your Lord.
under section 100.
Yes.
Let's assume I don't go for
30
rectification.
Extra 30 days power, they have power. There is an upper time limit of another 30 days.
So
It is 60 days.
60 in all.
16 all.
Next.
10th February. Seal number 49. Even Nirali.
Yes.
This matter, may I just request for 2 weeks' time?
Why?
This pertains to an issue under the Customs Act. An amount of 2 crores is illegally recovered from the petitioner.
How much?
2 crores had been paid Manoj, during the course of investigation. We had filed a writ petition seeking refund of that amount. The learned single judge was pleased to allow the writ petition directing refund of that amount. But alternatively, they permitted that if a notice is issued,
Did
proposed
we hear this matter?
No, it's not heard, but my lord, this was adjourned on the ground that the issue is pending before the Honorable Apex Court. Whether the Directorate of Revenue Intelligence could issue a notice or not, whether they are empowered to issue a notice. Now, my lord, that issue has already been settled by the Honorable Apex Court in the review in favor of the revenue. If that had been answered against the revenue, my lord, entire proceedings should have, my lord,
indeed.
There is one which arises from Bombay also, no? That Bombay.
That is, I think with respect to the goods were in transit and the amount was, my learned friend has filed the.
And
appeal
that is, my lord, LM Wind Power, where Maharashtra authorities had, my lord.
No, there is a Bombay order also, High Court order.
Yes, Bombay High Court order, my lord, that is, that, no, that's
that.
That is not.
No, my lord, that has become infructuous. That appeal has become infructuous for the reason that, my lord, we have already granted the refund.
We have noted it. We have. Yeah.
Your lordship heard me on that, my lord.
That's right. You have become infructuous.
Yes, become infructuous.
Just say at the request of counsel for the respondent, re-notify.
17 to
17.
That Bombay High Court has held that, my lord, the seizure made by the recovery made by the Maharashtra state GST authorities is not in accordance with law, has directed the authorities to refund it. But refund was granted by here. That's the.
Yes. Which is the next map?
50 to 53 urgent. 54 urgent, 55. Seal number 55, Sri Raghavendra.
This is the railway matter.
Yes.
Just continue.
Yes. Where is Mr. Abhinay? Yes.
If there's anything, my lords, that he has to say, let him complete it. Then once and for all, I will reply to it. And I've also made some notes which I could pass on to the bench.
Yes, Mr. Abhinav.
The amounts claimed by the appellant is not admitted by us.
Pardon?
Is not admitted by us. Not the case, my lord, that the appellant put forth is that for the period 2012 and 2013, he has executed X work with us, on which he has paid the amount to the service tax. This does not tally with the work, my lord, at page 165 and the amount paid at page 219. No, the tallying, my lord, the work, my lords, may take page 218, my lord, the first annexure for that first quarter between July, August and September.
120.
218, my lord. The financial year is shown at A4, my lord, the fourth column, 2012 to 2013. Return for the period paid is July to September. Page 219, my lord, is the amount that is paid at column B 1.1. It's about 1,35 lakhs. And for that period, my lord, the work that was executed with the railways, my lords would find at page 165. Really there?
But does your ticket says ki look here, for all these benefits you will claim, or what will happen to the caterer?
Not the-
He's also giving you service.
That is the second point, my lord. My lord, what is the work that was entrusted to the appellant was washing of the bedrolls and towels. This, my lord, is the convenience that we provide to the passengers while they travel in the night. This, according to us, is excluded by notification 25 of 2012. This, my lord, is to be treated on par with the services that is provided for use of washrooms and other services, something that is provided for the convenience of the public. This does not come under the purview of the service tax. The third contention, my lord, is that we are just the mediators. Unless we have transferred or recovered this amount from the passenger, we can't be held liable to pay the amount. The reason we state this is, my lord, that there is no demand that is made by the service tax department for the amount or the work executed by him towards us. Once there is an exemption under notification 25 of 2012, we can't be saddled with this liability. This
Exemption from,
the payment of service tax.
there is no demand.
Yes,
Why a claim has been made?
he has deposited on his own violation, my lord, and that he says that we are entitled to pay the refund.
Which period you have filed, you have paid, Mr. Raman?
My lords, between July 2012 to March 2014,
How much is the amount?
the amounts are 31,37,692 in totality.
At page 19, my lords would find the chart.
Okay. But why did you pay it?
My lords, this is a very, I am sorry to say this, my lords, very peculiar. My lords would please prepared a note of all his objections which he is raising and the answers to it. My lords, it is a self-assessment scheme under the service tax. I am bound to pay it. We don't have the concept of assessment here like in income tax, which your lordships knows very well. It's an indirect tax. I have to assess on my own and I have to pay on my own. The lordships will see, I have produced this, lordship sees. Section 70
No,
of the
his case, what he is arguing is unless there is a
My lords,
liability to pay.
there is a liability cast on me and it's a self-assessment scheme. I am liable to pay on my own. The department is not going to wait for me to pay and then come after 5 years. If they come after 5 years and found I have not paid, my lord, let us assume so.
You're right.
I have to pay with interest and penalty. No, will they reimburse me that? I have to comply with the tax law. So I don't think that is a valid.
What does the learned single judge say?
My lord, the learned single judge is only on this, that hurdle which I've crossed before your lordships is that it should have gone for arbitration.
That's it.
That is the only ground on which I have crossed that hurdle. Now, what I've done, my lords, is I just prepared a note of all his objections. If he has completed, my lords, I will deal with each one of them.
Mr. Abhinav, tell us. Yes. So this is your submission, in effect. No liability, you have not providing services. It's between the person who is giving the bedrolls and the passenger.
Amount initially, the first submission, my lord, is the amount that is claimed for is not admitted. He has not produced any proof, my lord, that the work for which we has done, that he has paid the service tax.
Is the amount payable against that service?
He may have thousands of contracts.
Suppose he was to give the evidence, you would pay.
No, that is something that requires adjudication. This is why the learned single judge says, may not go before the arbitrator to get this adjudicated.
Right, but he relying on Supreme
The
Court.
question that will have to be decided by the adjudicating authority would be this, my lord, whether the amount that he claims is the amount that he has paid with disrespect to contract or some other contract where he has been reimbursed. He can't have the double benefit. His word against mine. That requires on third party adjudication.
Okay, so it's not only on an admitted facts. If at all any liability is bestowed or liability is fastened on you, and also subject to an adjudication, that the liability is in fact of the railways, not of the passenger, then only something is payable by you.
And this
your case.
Yes, in submission.
That's in submission is case. Okay.
And
I will
notification
answer.
25 of 2012 is not addressed here, my lord. I'm sorry, I just have one copy. My lord, please look at the notification. This is issued under 93(1).
What is this?
This is the exemption, my lord, that is provided with respect to applicability of service tax in 2012. Whatever is provided for public.
But will this come in any of the section, in this clause 38? You have got a copy?
I'm sorry, my
Just
lord, I just took out a printout, my lord. I thought I had this.
You should give him a copy, no?
I'm sorry, my lord. I thought it would be taken up to.
You will read it, Mr. Raghuram.
I'll read.
Services by way of public conveniences such as provision of facilities of bathroom, washroom, laboratories, or toilets.
This is a serial number, my lords?
38.
38.
38. In nowhere this comes, my lords.
It's
I do
something
not
of a
know how
public
petrol
convenience.
supply will come here.
What is given is.
I'm unable to see where it comes here. And this is not the case before the single judge, my lords. This is a completely new case that they are making out. And if the lordship sees, this is
only after you are relying upon Supreme Court.
exactly.
This is basically on merit.
Exactly. But then
6 minutes.
please see, my lords, public conveniences. I'll read that. Services by way of public conveniences, such as provision of facilities of bathroom, washroom, lavatories, urinal, and toilets. This is meant for where they provide a toilet and take the sulab and other things.
No, but this is not exhaustive.
No, my lords, by way of when they say, then my humble submission would be public convenience.
Such as?
Such as.
2, 3, 4.
Exactly.
There can be further list.
But that belies their own practice of reimbursing this in Bombay. I have produced that certificate before your lordships.
What do you say?
Same contract, my lords. In Bombay, there.
Same contract.
Same contract in the sense, my lords, I have bedroll contracts with the Mumbai division. Where
They have reimbursed you there.
yes, I have provided
Was
that.
after the service tax came into play, 5 months. After the service tax came into play. it
Have
was
you
in-
filed? Have you filed objection before the learned single judge?
Yes, same
Let's
objection.
see your
First, my lord, may
objection.
kindly come
of
to
this
page
is it.
216, my lord.
What is the stand you have taken?
Lords, may first come to page 216, my lord.
216.
Last paragraph, my lord, is where we issue a reply and raise this ground of notification 25 of 2012. Now, my lords, may kindly come to my objections, my lord, at page 316.
316. Yes.
Para 317, my lord, para 5 is the raise with respect to arbitration clause.
Forget arbitration on merits.
On merits, my lord, 6, 7, and 8. And para 12. my lord. Supported by para 18 and 19.
Now, how do you answer paragraph 10?
Lordships will see my contract with railways is different from the railways contract with the passenger. For the railways, mine is an input service. Whether they embed it or not, this I mentioned, I made this submissions last time. Whether they embed it or not, they don't embed it or not, is not the issue in this. That is their policy which they want to follow. They are free to raise the fare or not to raise the fare. Fact of the matter, my lords, is the contract between me and railways is an independent contract. It is not dependent on the contract with the passengers. Therefore, my lords, the 10 cannot be, it's their input services. Under the Finance Act, my lords, my services are taxed independently. Can I, my lords, we take the converse argument, my lords. Can I say, since the railways has been exempted, they get a 70% abatement. You give me also a 70% abatement. That is not possible in taxation. As your lordships knows, I am taxed to the full extent of 12.36%. What the railways wants to do with it or not do with it, I can't dictate to the railways.
Okay.
If he has completed, my lords, I will go through all the questions and answers, and that will clarify what are all the issues in this. I won't take more than 15 or 20 minutes, my lords. I'll go through the whole question answers and clear it out.
Tell us, you don't dispute insofar as the applicability of service tax on this service.
My lord said, put this question to me on the 3 dates earlier also, my lord. I said, I'll take instructions. After that, we have not reimbursed. Southern Railway has not, Southwestern Railway has not reimbursed.
But how would you answer this, the other division?
My lord, that division, my lord, is with respect to a contract that was after the service action. We have not reimbursed anywhere. We have not reimbursed anywhere, my lord. What had happened was, when we called a new tender, they add that and they cite the codes.
You see, railways per se.
True, my lord, but I don't know, I'll have to get this.
Southern Railway.
I'll have to get this verified. What was the contract terms, whether it provided for payment of extra service tax. They have just produced the bill.
No, per se.
Contract depends.
Bedrolls, according to per se bedrolls, identical contract.
It is there, my lords. We have the same 13-14. For the year 2013-14, which covers our period, same period, they have reimbursed, which we have produced before your lordship. I can give you extra copies also if it
shows that.
Yes, my lords. No, I produced it separately. I have extra copies.
Is it there? Just see, check up.
I have these extra copies.
Contracts are different. This is for supply of bedrolls.
Contracts are different. One is by one zone, the other is the other.
No. Supply, this is for supply. The subject matter of this writ appeal is supply of bedrolls. My lords may see, my lord, it says work of washing and cleaning of soiled linen in AC coaches.
This is the same, my lords.
Let's see the terminology in both the contracts.
The whole contract has to be given, my lord. I just have
Yes, let's see the terminology. You will see where is the contract here?
Contract is at Annexure A 134 onwards.
Let's see that.
135 first paragraph.
Now it says the purpose of contract is
135 first paragraph. For the third line, not 135.
This was washing.
For the purpose of supplying bedrolls.
Yes.
Compulsorily on first AC, AC2.
Same.
Nature of work, my lord, here is different.
This is the same washing and cleaning is what we do, my lords. Lordship sees the rate is also 25 rupees.
Way is different.
No. My lordship see the rate is also only 25 rupees. Bedroll can't be.
But here what says is supplying of bedrolls.
My lords, that's actually, we wash and give the bedrolls belong to us. We wash it and give it. The washing charges are reimbursed. If your lordship sees the value of the contract is 21,44,000 for an approximate quantity of so-and-so set of bedrolls.
But what prevented them from saying even here, instead of supplying bedrolls, washing and this thing?
Please, my lords will see para 5. Because these are all new, every time a new technicality is being raised. We are finding it very difficult.
Last date, my lord, so we'll have to raise this.
137, please see, my lords, para 5. Hey, this is, you pick out one word from here, one word from there.
Washed, reputed.
Reputed in the absence of one washing unit which should have requisite. Please, now you're finished, please. Let me finish off. It's all there, my lord. Wet linen should be friendly back. See, they give us the what washing we should do also, what acid we should use. Everything is there. It's the same contract. Here they've described it as work of washing, cleaning of soil linen. It's the same AC coaches. Same thing is being done.
So the washing is inbuilt in the contract for supply.
Yes.
You can say so.
But they reimburse me only the washing charges. The bedrolls which I have, I wash it, supply it to the passengers and take it back. Wash it again, supply. This is what I do. This is my activity.
Para 2.3.
It's a washing which is being, it's the activity of washing, which wet washing, which attracts
Very well.
service tax.
Where is the payment terms here in the contract?
May first see page 136 2B, my lord, for which the charges are payable.
We will see that.
Where?
The licensee agrees to claim
Value of the
charges.
contract on the present composition is assessed. My lords will see it at page 130. 135. Value of the contract, my lords will see the second paragraph. On the present composition is assessed at 21,44,142 for an approximate.
Which, where are you reading?
Second paragraph, page
Yes.
135.
Yes.
So and so for an approximate quantity of 85,800 sets of bedrolls at an average weekly supply of 550 sets at a rate of 24.99 during the contract period of 3 years. So that is the washing charges which I incur, which they reimburse me. That is the value.
If you see 2A.
2A, if your lordship sees, I can't charge the passenger. That's what it says.
You're right. No, but it still say agrees to supply the bedrolls.
Yes.
Without collection of any charges from the
Exactly.
passengers.
Exactly. So I have to give the bedrolls, take back the bedrolls, and I am reimbursed only the washing charges at 25 rupees. Obviously, each bedroll will be more than 25 rupees. The worth of the bedrolls is several hundred.
If you read still 2A.
Yes.
It says this
and agreed to
express
claim
for
the
a period of
charges
3 years, agreed to claim charges of bedroll supplied to passengers traveling at the rate of 24.99.
Exactly.
Per set of bedroll.
Yes.
From the railway administration.
Exactly.
It doesn't say washing in that sense.
My lords,
my lords may kindly come
charges, my lords,
We'll come back. No, we'll come back after lunch.
That's why I told you finish and then I'll go.
Can I?
No, this would be which department?
It's the central tax department.
Just say that additionally, the liberty is granted to the counsel for the appellant to serve the copy of the appeal on the standing counsel. You have standing counsel?
Yes.
Standing counsel for customs. CGST would be there under the customs.
Yes. CGST and customs one and the same.
Under of the customs. Okay, thank you.
Parliament cannot
Yes.
55.
Therefore, what I plan to do, my lords, if he's completed, I'll just take 10 or 15 minutes and close this one. Let him, if he has nothing else to say, I will just summarize.
Hmm.
One cooler blanket, 2 bed sheets, 1 washable foam, 1 pillow cover, 1 face towel. This does not include washing. This is you take a material, for that you pay. Subsequent products they refer for cleaning and wash. That can't be paid on part.
No, will this not be part of the services? Providing bedrolls, not washing.
This matter comes under 38. They have an exemption because it becomes convenience.
Pardon?
Comes a convenience to public at large. By then, they come under the 38 of the regulation. The arguments are not recognized. The first matter is the more things they say. It's not tally with the things we do. You have to get the contract. For which aspect is not done. Now, this can be not work as a impact. The second argument was that under the clause 28 of the 2015 notification, there was an exemption for the service provided to the public spending. It is therefore content. That this there is a when they are traveling in night. This is the exemption, not service. The third matter that we are just transfer under point A to point. Because we have transferred this tax liability on end user. We can't be started. The argument they can refer that the railways had agreed and have paid in the service charge with respect to contract of the Mumbai.
But will it not be construed as a service, providing bedrolls? So what you say is the bedrolls are being provided to the end consumer or the passengers, not to the railways. That's your, but you don't dispute, otherwise it's a service.
Subsequent contracts of after 2014 were not paid for this.
And now, today? No, it would be.
They are not paid service tax in subsequent contract. This contract was in 2014. After 2014, there was an escalation in the charges of the rent you are paying for the bedroom. You are not paid service tax.
Okay. Now tell us one thing, Mr. Abraham, is it inclusive of all taxes?
It is, I will show the clause. Have you finished? I will start. Dry cleaning, my lords, was taxable up to 1/7/2012 because it was a positive list. All other services were subjected to tax from 1/7/2012, all services, except those in the negative list and in the exemption. Now, it is our understanding and their understanding also that this is a matter on which service tax should be paid, because the counter doesn't say this public conveniences, etc. I'm not able to see. Even if it is there, that is something for the tax authorities to determine, not the railways. Now, what was the contract form? Let us be clear on that. If a lordships could see the tender which was floated, there were special conditions of the contract. I'll only have to read that and lordships will get what it is. 358 page number. Please see this. Only the best quality linen, preferably branded. Have lordships have got it? Branded
Yes.
linen shall have to be procured for supply of bedrolls at the tenderer's own cost, duly bearing all allied expenses. So I get the linen, I get all the bedrolls, and I have to supply. It's my own. Tenderer should have washing plant, including all machinery at starting point of the trains where the bedroll supply is to be made. Washing plant should be owned by the tenderer. Linen should be washed through reputed laundries which shall have requisite number of washing and drying machines. Linen should be supplied in attractive eco-friendly bag, in which I will collect at the end of the journey. Please come to 5.1. That answers this completely. The tendering firm individual should be well established in the field of professional washing and cleaning services of linen. This is the condition of tender. Only experienced and qualified firms having proven credentials of unblemished performance in the reputed major establishments for similar work should only apply with relevant supporting documents. Similar work for the purpose of this tender means washing, dry cleaning, and ironing of linen garments for railways, airlines, major hospitals having 300 or more beds, etc. So this is essentially, my lords, a washing supply of my own bedrolls, which I have to wash and clean and give. What the railways is trying to do, my lords, in AC coaches, they say the people who travel should have the bedding supplied, which should be clean. Now, I should not take this from them and then supply it to your lordships without cleaning. That is the essence of the contract. So this contract, there is no doubt, it is for washing and cleaning. So it is what I'm reimbursed is 24 rupees 99 paisa. He told me supply of woolen blankets with 2 or 3 white sheets and pillow. If this can be given by railways to me at 25 rupees for ownership, I will gladly take this. I mean, what I'm trying to say, my lords, is that this can be for nothing other than washing. And 25 rupees only for the washing, cleaning, everything.
No, but effectively that material is being given to the passenger for the usage.
It is for the usage. That is the service. That is the service.
So effectively it cannot be, how can it be construed as washing and dry cleaning?
No, because the linen belongs to me.
Who?
Me.
Ah, that's right. So that's more reason.
That is the reason why.
It belongs to you.
Exactly.
You are giving it to railways after washing. For the passenger to use it, you take it back. The lien on the material is yours.
My lords, but I can't charge the customer.
You can't?
I can't charge the customer.
Ah, you can't.
So the privity of contract is between me and the railways. They say it is your linen. You have to wash and supply. For that washing, I will pay you 24 rupees 99. I will ensure that you have to give me clean. This is the contract. That is why they say.
But no, we don't understand this. It's your linen. Can the railway say you only wash and do that, but don't give it for our usage?
No, I'm not saying that. It's for your usage. But the control and possession of that is with me. So it becomes a service because I'm giving this service to the railways because railways wants this kind of a service to be provided to its first class, second class coaches. So this is the contract.
So the material is yours. You continue to have all constructive, possession or whatever you may call it.
Absolutely.
But it is for the usage purpose also.
Absolutely. There is no doubt on that. And for that usage, they give a service charges of 24 rupees 99 paisa. That is meant for the usage of the linen, which should be washed, clean and ironed. The essence, what does the railway want to do, my lords? They want to give neat linen for the passengers who travel. That is the essence. Now, my lords, will please take the sheet that I have given in the morning. Clause 6 also, my lords will say.
Now,
it's
whose
fine.
liability is to deposit with the GST?
The service tax is my liability if applicable. So let us look
So
at.
the person providing services would do it.
Absolutely. There is no doubt on that, my lords. The provisions of the law are very clear.
That's right.
The service provider has to pay the tax. Now it's my duty to pay the tax. The clauses in the agreement, if your lordships were to see at page 399. I'll just read it out, my lords. Please see note 1, my lords. This is what they're relying on. Tenderer should quote the rate, inclusive of all applicable taxes and levies. So my case is this. When I entered into the contracts, my lord, that is prior to 2012, when only dry cleaning was subjected to tax, the rates were inclusive of applicable taxes, which did not have wet cleaning.
We did not have
wet cleaning. I do wet cleaning. Basically, I do wet cleaning. So the rates were quoted without any service tax. So after 2012, when I had to deposit the service tax, my lords, I am claiming what I am liable to pay now, which is not envisaged in the original contracts. So I had shown your lordships, I think about.
When was this wet cleaning?
1/7/2012.
And what is the contractual period?
The contractual period, my lords, is it starts from 2008-9 and goes up to 2011. These were the contracts.
July 12 to 14.
This July 12 to 14 in respect of contracts which were entered into prior to 1/7/2012. These are all contracts entered prior to 1/7/2012.
It was prior to 1/7/2012.
Yes. When
now,
yes.
Does the stipulation says that this would be inclusive of all taxes? What the provision says is
inclusive of applicable taxes. So I cannot charge what is not applicable. So I have my quote which I gave at 24.99, my lords, was without service tax because it was not applicable. During 2007, 8, 9, 10, 11, there was no service tax.
No, was it a fresh contract, fresh bid?
No, man.
No, it says, if you see 399, it's okay, 22/12/2011.
Yes. Yes. These were all contracts entered into prior to 1/7/2012, where service tax is not at all part of the rates. The short issue which comes, my lords, is after 1/7/2012, when I am liable now.
Where is the negative list?
Negative list is. My lords will find it at.
Yeah, this is the one which he has filed.
That is, my lords, what he has filed is the exemption notification.
Okay.
It's an exemption notification. Negative list, my lords, are page 10 onwards of today, what notes which I had given. If your lordships will see negative list of services, the only entry pertaining to railways, please see entry O, my lords, on page 12. This is a railways liability. Service of transportation of passengers with or without accompanied belongings by railways in a class other than first class or an air-conditioned coach. Why they did this, my lords? With effect from 1/10/2012, they made first class and air-conditioned coaches taxable.
Now, what does this say?
This negative list, my lords, is negative list shall comprise of the following services.
Negative list means?
That which cannot be taxed.
Which cannot be taxed.
Cannot be taxed.
Service of transportation of passengers.
With or without accompanied belongings by railways in a class other than first class or air conditioned. So first class and air conditioned can be taxed, others cannot be taxed. This is a negative list.
And if you see I've seen somewhere.
My lords.
The stipulation in the contract.
Yes, ma'am. This is what I showed your lordships, page 399. They do not dispute, my lords, that the rate is inclusive of service. They don't dispute that. All that they dispute, my lords, is now you may be liable to pay, but we can't reimburse you because those contracts don't talk of it.
No, if you see page 135,
My lords.
yes, administrator, for the purpose of supplying bedrolls compulsorily on first AC, AC2 tire and AC3 tire on demand to first class passengers by
Yes.
train. We don't know why they use the word first class passengers.
The train composition consists of 2 AC tire and 2 AC3 tire.
No, just above that.
Yes, yes. Yes, my lord.
Compulsory to the first AC, AC2 tire
And AC3 tire.
AC3 tire is not there. Where the GST, where the service tax would be applicable in terms of this.
Air conditioning, my lords. All air conditioned.
And air conditioned.
Air conditioned. So, my lords, the only case is, my lords, that in those contracts, there's no doubt that service tax is not included in the rates. What they're saying is, since in those contracts it's not included, now you're liable to pay, we can't reimburse you. But that is the reason why, my lords, I had produced several decisions of the courts on the same issue. If your lordships were to see, kindly see my. I will go from the written, your lordships would see. Page 3.3, my lords. You'll see, I had shown your lordships this decision, Government of NCT versus MBL Infrastructure. Where?
Just show us. No?
This compilations.
That compilation. Yes. Please come to 156, my lords. Page 146, my lords, 146. 146.
You said 146?
146. Please see the issue, my lords. What the High Court says, the only issue, paragraph 1, which arises for consideration before us is whether the appellant is required to reimburse the service tax which came to be levied post the acceptance of the bid of the respondent. Then, my lords, this is a road contract where it was exempt and then tax became levied. Your lordships will see para 2.1. The respondent herein was awarded a contract for maintenance of Ring Road and Outer Ring Road for a period of 3 years by the appellant. In respect of the said contract, a bid was submitted on 15/4/2005. The said bid was accepted on 6/7/2005. Formal contract was executed on 24/8/2005. It would be important to know that in the interim, a notification was issued qua imposition of service tax on road maintenance. The said notification was issued on 27/7/2005. That is post the contract. Now, what their lordships would say, my lords, is very, very important to see. My lords, will please come to page 148. Where they look at the GCC, my lords will see the clause. All duties, lordships have got it. All duties, taxes, royalties, and other levies payable by the bidder under the contract and under applicable laws or for any other cost shall be included in the rates. Prices and total bid price submitted by the bidder. A reading of the aforesaid clause clearly indicates that the respondents is required to factor in all duties, taxes, royalties, and other levies which were enforced under applicable laws or for any other cause at a point in time when the parties had entered into a contract. The last part of the said clause makes that abundantly clear by stating that the rates, prices, and total bid price shall include all duties, taxes, royalties, etc. payable by the bidder on the contract, either under applicable laws or for any other cause. it cannot be said that the service tax which admittedly was notified on 27/7/2005 would have been in contemplation of the parties when the bid of the respondent was accepted. Admittedly, the bid of the respondent was accepted on 6/7/2005, which according to us is the date when the contract between the parties materialized. The execution of the contract on 24/8/2005 was according to us a mere formality. Therefore, the service tax which was notified on 27/7/2005 would not have been in contemplation of the parties. We are also of the view that there is no provision in the contract which by implication would could be said to take into account such an eventuality. Having said that, my lords will see, please come to para 3.9, page 149. A perusal of the section would show that unless there is an intention to the contrary, this is 64A of the Sale of Goods Act. If there is any change in tax increase or decrease, parties have to bear the necessary consequences which flow from the increase or decrease in tax. Applying the same principle to the present contract, we are of the view that the appellant would have to bear the burden of service tax which was imposed with effect from 16/6/2005. There is also a statutory indication that this is important, my lord, so that this ought to be the result. If one were to advert to the provisions of Section 83 of the Finance Act, 1994, read with Section 12B of the Central Excise Act. Section 83 of the Finance Act by incorporation takes recourse to Section 12B of the CEA. Section 83 of the Finance Act as well as 12B for the sake of convenience are extracted herein below. Then after extracting it, my lord, at page 4.1, what they say. A conjoint reading of the two sections would show that there is a presumption that service tax is required to be recovered from the user of the service. This, combined with our reading of the contract as executed between the parties, brings us to a firm conclusion that the appellant would have to reimburse the service tax which has been imposed on the respondent. And there are several other decisions which I have enclosed, my lord. So this case was on all fours. Unfortunately, also, my lord, the single judge notices this case says it's not applicable. That is why we are before your lordships, unfortunately. Now, there are so many other cases which also say the same thing. So our plea is simply this, that when I entered into the contract, both of us never had a contemplation of this tax. Subsequently, it was imposed by the government. Now, in line with the jurisprudence that is there, this has to be reimbursed. And that is all that we are asking. As far as his plea that it should have been adjudicated by, it's not so. There's no need to adjudicate because the liability is on me, I have to pay. This morning, this is not in the counter. This morning he said,
how much would be the liability or the effect of the service tax? What they intend to pay is 24 rupees 90 paisa. They say this exclude the service tax.
12.36% will come to roughly, my lords, around 2 to 3 rupees.
2 to 3.
2 to 3. Per bedroll.
10%. Just
it is 12.36.
About 10%.
Yes, 12.36.
This is 10.
Oh, I'm roughly telling. I'm not.
On each bedroll.
Yes. 24.99 plus 12.36 would now be the rates, which my lords will see. They have given this. They have given the, in Bombay, my lords, that is being done.
See, very interestingly, in fact, we wanted to put it to him. The service which is being provided in that division, Western Division, Bombay, and here, effectively is same. The washing, this thing is relatable to what? To bedroll only.
Bedroll.
There, the nomenclature of the contract is washing this. But of what? Of the bedroll, you will not pay for washing him unless and until he provides you the bedroll to the passengers.
Yes.
So maybe the contract nomenclature says for washing this. In this case, it talks about giving the bedroll.
That is what the tender says. If your lordship say come back to 5.1 of the tender, it uses, these are alternate terminologies used. Supply of bedrolls or washing, both are alternate terminologies.
But one thing is, you will not pay them for washing if they are not giving it to you. They are giving washing for what purpose? So that ultimately the bedroll is given for the usage of the passenger.
Absolutely. I have no doubt on that. My lord, this is, when they give a certificate, they just indicate what it is, my lords. It is not given exactly. When they say work of
Not work. It's not so happily worded in the set, very well. For the supply of bedroll, you will supply bedroll after washing everything, doing this, so that they are neat and clean for the usage of the passengers.
That's what they put in the tender. But as your lordships correctly say, they could have simply said that instead of putting everything.
Everything, washing. See, we are surprised that contract is for the purpose of washing everything. He will say, okay, my bedroll, I will wash it, keep it at my home. You give me 24 rupees. I will not. Where is the supply?
My lord, that.
Mr. Abhinav, where is the supply in that Bombay? Entire
Agreement.
that can be an issue. You are right. Okay, let's understand that. Okay, now possibly that this contract may be where you have procured the bedrolls, you have spent the money, you are giving only for washing. He is washing, you will pay 24 or whatever is it. For that also, he is providing services. You will pay, GST is payable by you. So ultimately, he is providing services. If that is one scenario, the second scenario is the railway itself is providing bedroll to the passenger after it is washed. Okay. So this is privity between the railway and passenger, but you are not claiming from passenger. You are not claiming from passenger in that eventuality. Okay. But you are making it inbuilt in the ticket, although not under the head of service tax. If you take that, in this case, you are actually providing a bedroll given by a third entity, third person, to railways for the benefit of the passenger. You're right. Now, who is providing services to the railways? Him. So if he is providing services, why not the consequence be same? Okay, we'll let him finish. And just shows the last order. Yes, Mr. Aguraman, is there any other judgment other than this?
There are number of judgments in line with this.
In substance, the position is this.
Yes.
Though contract was executed before actually, this service tax was introduced with regard to a particular service. And when the bid was submitted, it was not contemplated that service tax is also a component which he must load it for the purpose of submitting the tender. But subsequently it becomes payable. The liability would be on the person who is taking the service, not giving the service, taking the service.
Exactly. And in this case, the person who's taking the service is the railways, because it's with him that they have the privity of contract.
Okay, that's all. That's enough. Anything else you want to say?
My lords, on the wall, he said that it's not voluntarily done, and that whatever he said, that I think I've answered that there should be an assessment before we should come. I don't think that is the right position in law.
Assessment?
He says no authority is.
No, what he says is, these are all in the realm of disputed facts.
There is no disputed fact here.
I'm sorry. What is being said is this. These are all in the realm of disputed facts, in as much as that whatever you have paid 35 lakhs or 34 lakhs was actually on account of service rendered by you for this contractual period for the supply of bedrolls. You have deposited some amount with the authorities, but is it actually for this? That's the submission.
My lord.
And these need to be adjudicated by the arbitrator in terms of the contract, dehost the judgment of the Supreme Court, where you say very well. In what he says is the Supreme Court judgment, in fact, would be applicable where there are undisputed facts on a pure question of law.
Exactly. And that's to answer that, my lords. There is no undisputed facts because they have not said in their counter that they dispute this 31,37,000 amount. They have not said that you have not paid this. So that is undisputed that we have paid. The plea that this morning was taken was a completely new plea. That in the returns, some figure is there, here some other figure is there. Lords, that I would like to show
very well. We will ask you.
Yes, yes.
Whatever you have paid for which you have made a claim.
Yes, it is included in that return. I will show your lordships.
Yes, sure.
I will show your lordships what we have done. We are a centralized registration, my lords, where we pay tax in Bangalore for the entire country. If your lordships would please come to page 165 for a moment. Please see the, just a representative sample I will show your lordships. Please see the service tax amount at the third column, my lords. This is 2,67,736. Lordships will see more or less the same figure across the months. And then it actually comes down between April 13 to March 14. Please come, my lords, to page, he said page 219, that figures are not tallying at all. He should not have shown that figure at all because 219, my lords, for a moment.
How would you demonstrate?
My lords, this is the value of taxable services. So this is only the value. Please come to page 229 for a moment. Your lordship sees the figure there at D8. D8. 16,31,425, which is 8 times the amount which I have claimed here. The lordship sees every month I'm paying this. 16 to 20 lakhs for the entire country as a whole for this. So, and we are claiming only 2,27,000 in this. It is included in this returns. I am paying the entire thing.
No, but you may be, but you have actually paid for this contract. How do we get it?
I have actually produced this. They have not disputed it.
It's a different, but no, for the satisfaction of the court.
I can produce even the worksheets and I will place it on record before your lordship. I have no problems with it.
Because
wherever I can retrieve the records, I can check with the employee who's sitting here and place it before.
In a normal recovery suit also. Forget, let's assume they were ex parte, but still the court need to satisfy itself the amount is payable.
My lords, in principle, if the amounts it is decided that they should be done, my amounts are quantified. I can place the records before your lordships, but the amounts are quantified. I can't change that because the 12.36 is fixed. And I have challans to prove that on overall I have paid.
Yeah, right.
I can produce the challans also.
You're right. But this breakup of what you have paid in cumulatively,
yes,
with regard to all the contracts,
yes, maybe
different denominations or different percentages. Maybe I think this would be only a common percentage or 12%.
12.36 was common across.
Common for all. So maybe you are paying in lump sum, but how would we say for each of the contracts? Let's assume for a moment the GST authority says, look here, you have not paid for this contract.
The lucky thing here, my lords, is that it is all invoice-wise calculations to be done. So I have to do it on accrual basis. So all the invoices for every month are already there, raised and kept ready. So that's really, I don't see that as an issue, my lords. Actually, to prove is not an issue.
No, no, but for the court to come to a
I
conclusion.
will place it, or if your lordship says I should get a chartered accountant
Let's
certificate,
see
I'll
the-
place it.
Let's see the finding of the learned judge.
There's nothing, my lords. He has simply, he has talked.
He went on the stipulation, arbitration.
Yes.
He did not go that there are disputed facts.
No,
We would not go.
he is trying to say you should have gone before the arbitrator. That's it. Even the
Then
invoice-
possibly, Mr. Raghuraman, you must place on record all the material.
Oh, yes, my lords, actually, in fact, if your lordships were to see, in fact, I've done it train-wise. I have given a sample also, my lords.
Show us.
Page 294, for example, my lords. I will place that on record, my lords.
Show us this.
294, my lords.
We have 294.
Please see here, this is
Petrol.
this is the invoice which
4538.
supply bill, supplied bedrolls and AC coaches of train number, lordships have got it. 226932, supply of bedroll, 14,000 quantity, 24.
Please supply tax is
44,006.
44,000.
Yes. All this have been given to the railways. I have given, in fact, invoice-wise details to the railways. Yeah, I have written 4 or 5 letters with the invoice-wise details.
Now, if you see just agreement number, just third,
Yes, yes.
just under that heading, supply of bedroll for the year February 2013. You say agreement number is BM
2012.
bedroll.
Yes, yes, 2012.
This is 12494.
I will what I may do, my lords, is I'll try to correlate it and give it all the, in fact, the entire invoices can be given because we have provided it to the railways.
But if you come to 134,
Yes,
that contract number is different.
yes. Your lordships, here I've given a sample to show your lordships how it is. Only a sample. I can produce that also. I will surely produce. But this is a sample to show your lordships. Every invoice is raised on the railways.
Possible
With
with the
service.
challan.
Yes, absolutely. We'll produce with challan.
But the test would be still this, that you have satisfied the court that you having paid it. So there are no disputed facts. If ultimately we have to agree with you on the issue of arbitration, possibly you are relying upon Supreme Court. On the merits of the claim, that there is nothing which is disputed, which cannot be disputed in
Yes.
view of this material which we
Yes.
have placed.
Yes,
We will see that.
yes. So lordships were to let.
What do you say?
My lords will see. I'll see if I think I have got it. Lordships will see page 205. This is the letter, my lords, I wrote to the railways. 204, 205 sets out. The repeated letters, one sample.
205.
205. Please see 204 and then 205. 204 gives the total amount, so the repeat letter. 205 onwards, my lords will see, I have given the train number invoice-wise billing details from July. It is there. My lords will see this goes on up to 207 and then continues for that year and 208 the next year. This continues, my lords, up to 210. Invoice-wise details I have given. This I supply to the railways.
And tell us one thing.
My lords.
Now, what is happening to all these contracts?
My lords, they have, after these 2 years and this disputes.
And this is the first case you have filed for the reimbursement.
I think in
There are so many contracts. There are so many, times you have paid the GST.
My lord, in Bangalore division, only this 2 years, after which they discontinued. We did not take up this.
Bedrolls, no
My lord,
contract.
Without the service tax reimbursement we are.
But now what? No, tell
In
us,
loss.
we just want to know.
Yes.
This is in one such case because since this contract originates from Bangalore,
Yes.
you have filed it. There can be other contracts elsewhere
Yes.
in the other jurisdictions.
Yes.
What is your claim? Have you filed any claim?
I'll take instructions and tell
You're
you.
getting, I hope we are clear.
Absolutely.
This is because the Bangalore is the place.
Absolutely.
in the context of other jurisdiction, other railway divisions,
Yes,
did you make a similar claim? And if yes, what is the risk?
I will take instructions. I will take instructions.
Because it says so many things, Sangamitra, this Bhagalpur,
Yes,
went to
all,
Bihar,
whatever
Jodhpur,
comes,
Rajasthan,
my lords, this is originating from here, those trains,
those trains.
only from here, this region, Southwestern
So
Railway.
it's exclusively Southwestern Railway?
Yes,
No other divisions?
no, this is only for this.
Oh.
All originating from here,
Now, this amount which you are claiming around 33 or 34 lakhs
31.
is cumulative of all the contracts?
All the during this period, everything that we have raised here, invoice wise, we have listed it.
Acha, in this division, you have raised.
Yes,
Not only that particular contract which you have shown at page 134,
everything.
everything.
Wherever they have not reimbursed to me, I have included here. And in fact, my lords, all the invoices which I have raised on them, they have not reimbursed. They had taken a uniform policy not to reimburse on any invoice which I raise on them. So I have given the invoice wise details, all these invoices.
Just said, you will file it on record.
I will file it. I will file it.
Yes. No, it's all right. That we will see. No, mind it. What Mr. Raghuraman is relying upon the judgment of the Supreme Court. Although though it was in the context of an arbitration. 4 point. Page.
150.
Yeah.
Conjoint trading.
Hmm.
Contractor shall agree that you have to, release charge will have to be collected from the passengers during the receipt. Further clarified your act. Page 139.
But tell us, Mr. Abhinav, we have been traveling also. Does this happen? Where?
Yes, sir. Oh, I don't know.
No, we are talking of this year 2012-13. We have not paid anything every time, anytime.
My lords, I'm sorry, my lords. Lordships asked me some question.
No, he is showing page 130, 136.
Yes.
He says there is a stipulation that you would charge the passengers.
I cannot, my lords.
See that stipulation. Come to 136, 2D.
2A, my lords.
No, 2D, just at the bottom. The sole right of collection of bedroll charges
That is
for the
only, my
supply of
lord.
bedrolls.
That is only on one of the trains on which we have no qualms. We don't have a claim on that. The lordships is 2A. That will be relevant. 2A, please.
See, these contract, they all cut and paste. No application of mine. We will show you. In fact, while I was just reading it, there are so many, anomalies, or there were some errors.
That is true, my lord. That is true. 2A, in fact, they say you cannot collect any, because the
How would you reconcile A and B, A and D?
This is something, this is being raised for the first time. Lordships.
Now, what will you file, Mr. Raghu?
My lord, shall I file the payment challans or reconciliations showing in my returns around each month I have showed 16 lakhs, 17 lakh, 18 lakhs. So along with those returns, I will show the that I have paid that amount.
Invoices also.
Invoices I have produced already. I can give the entire invoices for the 16 lakhs also to show your lordships that this is also included there. That I can do.
See, your claim is for 35 lakhs.
I'm for 31 lakhs, my lords, that I have already included here. The invoice wise I have provided here.
You have to satisfy us that this is the claim which I have made.
Yes.
And I have actually
Paid this.
paid
Yes.
against this contract.
Yes. I will.
Or against this contract or all the contract with Southwestern Railway.
Yes, all the contract.
For which you have made this claim.
Yes. I'll satisfy that, my lords, but I can do it in this way. I would suggest my lordships may correct me if I'm wrong. Invoice wise, I filed this. Invoices, my ST3 returns which I have filed. Then I will give your lordship the reconciliation of the amounts collected in each of this, where all I have collected, and tax paid challans to show that in entirety I have paid the tax.
We will just say that. We just say that we have all again heard Mr. V. Raghuraman and a senior counsel for the appellant and Mr. Abhinav YT for the respondents. Mr. Raghuraman seeks and is allowed how much time?
My lords, maximum 2 weeks.
2 weeks to file on or before. Seeks time to file additional documents. Let the same be filed on or before 7th of January 2024 by giving a copy to Mr. Abhinav, who shall also file an additional affidavit. Additional affidavit to the writ appeal as well as the additional documents which is to be filed by the appellant. He shall also incorporate in the additional affidavit the stand of the railways, the stand of the respondents in respect of a submission made by Mr. Raghuraman that the Central Railway in a contract executed by with the appellant had in fact paid the service tax, had reimbursed the service tax. Full stop. The same shall be filed by Mr. Abhinav within 3 weeks of the filing of the additional documents by the appellant, by the counsel for the appellant. Okay. Just have it, ma'am, 3 weeks. 14, 21, just say last week of January. Have it first week?
Third of.
We have, this is, yeah. Give it, ma'am, first week of February, no issue.
3rd of February.
Should my lords mark it as for further hearing?
Pardon?
Should my lords mark it as for further hearing?
No,
Because
we have,
it's
so
complete.
we have heard it. Not
My-
only this earlier order also say, Mr. Raghuraman.
My lords. Obliged.
Said we have heard you. We have heard Mr. Raghuraman for the appellant. Say so.
Deeply obliged.
Next.
Nine.
Okay.
Serial number 59.
You say none for the parties adjourned to.
11th of February. Serial number 60.
I appear for the
Appearing for respondent number 2, my
appellate
lord.
balance.
Kindly pass over the matter.
My lords, this is a commercial appeal, what I have filed on the order
My lord,
passed by the
kindly
commercial
pass over the
court.
matter.
You appear for whom, ma'am?
Respondent number 2, my lords.
Your counterpart is here.
Yes.
Yes, my lords.
What is this? This is,
My lords, commercial suit was filed before the commercial court by the wife and the 2 children because the
how long this would take?
My lords, the suit, was,
711,
yes, my lords.
on which ground?
My lord, so the ground is that I don't fall under the Commercial Court Act first. That was the application file. And second thing is the suit has to be returned back to the to be submitted in Hubli. That is on the jurisdiction point.
Now, why don't you, what is the issue about?
My lords, the issue is, my lords, the respondents had flouted two social security schemes. This is Indian Medical Association Hubli. It had flouted two social security schemes, and the social security schemes certificates, I have already produced two documents, my lords. One is an innovative family benefit scheme, and another is Silver Jubilee scheme.
Which provision you get covered in the definition of commercial disputes?
My lords, I get covered under 2 subclause 1, subclause 20, my lords. Assurance, insurance, and reinsurance.
Insurance and?
Reinsurance. 2 subclause 20. My lords, that is insurance and reinsurance.
And what is this scheme about?
The scheme is about providing benefits to the permanent disabled people and the death, those who worked at the time of COVID, my lords. And
what does the, okay.
My husband, he passed away because of COVID pneumonia. He was a treating doctor.
Oh, you were a doctor?
Yes, my lords, I am a doctor.
You have taken that scheme?
Yes, my lords, I had taken the scheme, and I have made the payment from Bangalore, and it is also written in the certificates.
How much premium you paid?
My lords, I had paid.
Is it a one-time premium?
Yeah, it's a one-time premium. One-time premium, 2 schemes I purchased, two schemes I took. That is.
What is the ground on which he rejects it?
My lords, the ground is, my lords, the social security scheme was flouted by this particular Indian Medical Association Hubli, and the aims and objectives, my lords, I have already produced. My lords, the aims and to promote social, moral, medical, cultural, educational, and financial help to the members and to their families in the event of unforeseen circumstances, and try to make up any welfare activities for the benefits of the members and families, to render all types of helps and assistance for the members who suffer permanent disability, and to the families of members in the event of death of the member. My lords, here what happened, I was a treating doctor.
No, let's see, what does the court below says?
My lords, the court below said, my lords, I don't fall under the category because this particular jurisdiction, Hubli, is in the bylaw of that particular, and I have to go to Hubli.
Then it is not commercial, then it's more on barred by law.
Yes, my lords. And even on, I don't fall under the commercial dispute also is the ground what the lower court has taken, my lords. Because 2 grounds.
Now, what do you say on Hubli?
My lords, Hubli, I don't, because, my lords,
Where is the stipulation?
My lords, yes, my lords.
Now tell us what is the relevance of Hubli?
Yes, my lords. It is under the bylaw wherein they have fixed the jurisdiction. In the bylaw, they say, my lords, at ink page.
Is the headquarters,
yes,
of the registered office of this IMA?
Is in Hubli.
Is in Hubli.
Hubli. But they floated the scheme all over Karnataka. And I am a person who is in Bangalore.
But the parties have decided to confer the jurisdiction in the court, on the court at Hubli.
No, my lords, no agreement happened.
But bylaws, you are governed by
bylaws, yes, but that was not mentioned in the certificate.
Your registration is under what provision?
My lords, my registration under the same provision, but my registration certificate may kindly be looked into, my lords. I am a permanent resident of Bangalore.
Where are the bylaws?
My lords, bylaws I have produced, my lords. I have produced last.
Show us that.
I have filed 2 doc.
Show us that.
Seconds.
This all, the parties can confer a jurisdiction on a court.
Yes, my lords.
Provided the court has some connection with the dispute.
My lords, the bylaws jurisdiction point comes at subclause 12.
Which page?
Madam,
what is this?
Court officer, last time you had a book, original suit though, file money. I have filed 2 sets.
You have filed list of documents.
Yes, my lords, additional documents on 4th December. My lords, 37 may kindly be looked into, my lords.
37.
Jurisdiction, subclause 12. My lords, jurisdiction of the operation of the society extends all over the Karnataka state territory. The legal jurisdiction of the society is at Hubli, and setting a dispute by arbitration rather than through the court is preferred. This is the 3 points what is being.
Would you answer this also arbitration?
My lords, what has happened is, my lords, at that point of time when the certificate got flouted, the bylaw was not circulated to me, my lords. It was COVID.
Where is your registration certificate?
My lords, registration certificate at ink page number 41 and 40 and 41, my lords. First certificate is Silver Jubilee Scheme.
Where is your application?
My lords, my application is there with the office, my lords. It is not there with me.
What?
I have been given a certificate, Silver Jubilee, so Subbaraju SA of Bangalore.
Where is his application he has submitted? Has he filed? He must have said everything in that application. Have you filed any? Where is your application? Under 711. Have you not filed the application?
No, my lord, I don't have a copy of that, my lords, because once at that point of time, it was COVID, my lords.
What is 711 file for? What were the agreements?
My lords. Return of plaint.
710.
710.
710. But you must have said so. Why return of plaint? Where is that application? So you have not invoked the arbitration as an alternative dispute mechanism. Even subject matter would be determined by the competent court. It could not have been decided by this court. See, when you are challenging the very competency of the court, it is irrelevant which is a normal suit court or civil court or a commercial court. You will say, look here, though he has filed a suit here, but this suit need to be filed at Hubli, that's all. In Hubli, when the matter will go to the commercial court, you will take the plea, look here, you will not have a jurisdiction, but a normal civil court will have it. That will be say. That's so here your objection was on a territorial jurisdiction. Territorial jurisdiction of a court in Bangalore to look into it. That's right. Don't know, you may have to file, you have to file, obviously. Pardon? We don't know that court will consider. Tell us one thing otherwise. A court which is not competent to go into it, will res judicata come? We don't know. You will argue, we will look into it. But today your primary reason is Bangalore court doesn't have a jurisdiction. That's right. How would you answer that?
My lords, this particular scheme was floated and I made the payment from Bangalore. And my lords, there is one judgment also had relied upon of this honorable court.
Only see that application form which he has.
Yes, my lords, that application form is not there with me.
That application form says he will be governed by all bylaws, everything. That's the, then he will think of going to Hubli. How would we know? We don't know. You may say, that's your saying. Show us from the black and white. You need to produce that. Okay. At the request of counsel for the respondents to produce the application form submitted by the petitioner to seek the benefit of, what is the scheme called?
It is
Social Security Scheme. When do you want? Re-notify, just give after the case.
My lords, a copy may be given.
The same shall be filed by giving a copy to the learned counsel for the appellant.
24th January.
Next.
Much obliged.
62. Government to head. 62.
Did we hear this matter? Recollect I we heard it. Have they filed objections? None for the parties, re-notify.
10th of February. Two matters. Serial number 2.
My lords, I appear for the respondent.
Yes, ma'am.
My lord, the appellant was to give some short reply.
Where is Mr.
He's
Kamal?
held up in another court, will come.
Okay, we'll just pass over.
Please.
My lords.
33.
Yes, ma'am. We'll just recapitulate whatever
Yes.
you have argued. It just,
My lords, the issue was with respect to SVLDR scheme, my lords. It come from an order of the single bench where the order stated that no opportunity was provided to the other side, my lords. It was acting as against the principle of natural justice. And direction was given to the department to issue Form 3, my lords. That's the Form 3 as per the prayer itself, my lords. And subsequently to set aside the show cause notice issued by the department, my lords. The same has been allowed by the single bench, my lords. Before this honorable court, my lords, our contention was that we never quantified, there was never a quantified audit report, my lords, that was given to the other side. The final amount was not ascertained at all. That's the contention taken by the department in this particular petition, my lords. And
so
then
how that would be relevant insofar as the learned single judge order is concerned?
my lords, it goes on the merit that the show cause notice itself is illegal, my lords. They set aside the show cause notice issued to the other side, my lords. We challenging that the show cause notice shouldn't have been set aside since the demand itself was not quantified. They never appeared before the department and the demand was never quantified.
Then what is the use of show cause?
My lords, show cause.
What is the use of show cause?
Show cause notice, my lords, the issue was that the contention of the other side also, my lords, let me just recapitulate, my lords. So basically, my lords, Form 2 was issued by the department, my lords.
I will issue show cause, but I will not tell you what is the effect thereof. But you reply.
My lords, the issue was, there was a contradictory issue by the department also, my lords, in this. We in fact accept their computation also by
You
issue.
should be graceful enough to say so.
Yeah, my lords, I'm accepting to that, my lords. I'm assessing this honorable court.
That's
also.
how troubling, the citizens.
Yes. My lords, I understand there's a department appeal, my lords. In VRB, I'll have to bring to light all the facts that are before this honorable.
We will go into this, who has decided to file this appeal
My lords, that is,
and impose cost to be recovered from him.
my lords, I have no idea, my lords. I've recently come on record, my lords.
See, not like this.
Yes, my lords, I understand. It's a very difficult case, my lords. On the face of it, the allegation is that there's fraud and misrepresentation on part of the declarant, my lords.
Now let's see the learner single judge order.
Yes.
Does he give liberty to you?
Liberty to, my lords, no, there is a specific direction given to us to issue Form 3, my lords. At page 19, the order starts, my lords. Order is captured. The operative portion at page 23, my lords.
This is item. Amma?
33.
Let's see the impugned order.
Yes, my lords. Page 19, my lords. The orders. First item. The operative portion, the result of the petition, my lords, is at page 23.
Jagdish from the computer branch. No, are you saying
Yes, my lords.
what has been, who has shown the figure in Form 3? They have shown it.
My lords, they had shown it. Subsequently, a Form 2 is issued by the department, my lords.
You have issued
Yes, my lords.
quantifying the figure.
Quantifying the figure, yes, my lords.
So then what follows?
My lords, ideally, Form 3 should have been issued, my lords. But however, there was an issue of fraud and misrepresentation, which was investigated by a third agency, my lords. That's respondent number 3 in this. Based on which show cause notice came to be issued, my lords, in the interim, when this was simultaneously done, my lords. But this came to light at a later instance that investigation was ongoing. In view of the same, there was show cause notice issued, my lords. That is why Form 3 was never issued.
What is the purpose of show cause?
My lords, there was a demand in excess of 3.7 crores that was made, my lords, in the show cause notice. The computation that was agreed initially was around 36 lakhs, my lords. The difference amount was substantial in view of the same.
Jagdish, come here. Cause notice.
Yes, my lords.
You said what is payable?
Yes.
Okay, you have said so?
Yes, my lords.
Did they submit reply?
My lords, they have not participated in that. They directly approached before this honorable court, where the single judge had set aside the show cause notice, my lords.
So quantified the earlier figure, ma'am? 35 lakhs or whatever. But why did you submit reply to the show cause?
When we got our application, I am bound by the scheme. Now the scheme, there is a cutoff date of 30th June 2019 as the date within which any quantification has to be denied. Now that quantification, there was a paper which developed that it was going to be conducted even an admission from my index on paper saying this is my voluntary contribution is acceptable as a contribution. Now that apart, I already had a contribution from the department to the audit. That is not in this. Now that audit inquiry also had a figure much higher than 30 lakhs. Why I came to pay only 30 lakhs or rather offer to pay only 30 lakhs because the scheme permit 70% covered as a discount over any voluntary. Because the scheme wants legacy disputes to come to an end. And the scheme objective members as well, their statement of objection reason. Is the fact that dispute resolution in the previous era before DSP has to come to an end. That is why the scheme is given a very discount. That is the range of difference my not been noticed also in the Shoka notice for payable and not that the audit inquiry and the Shoka notice have that. Now, there are 36 lakhs. I have to adhere to the intimate my willingness to enter into the scheme by signing form. I do that. The department has to come back to me by form 2 and say whether that quantification is acceptable to them or not. Now, as I understand very fairly considered, the department has issued form 2 in form 2 34/2020, they come up with the first notice for third party, the investigative team of the department. They issue a notice, say the rest of the information gathered in the finding of order, and therefore
This is by the third agency.
it's not my testing order. It's like an investigation order. They issue a notice. That notice, we don't sell one. We are already participating under the scheme. We include them, say my team application. And however, they reject my application at the stage of issuing the form, which cannot be done according to us. Which form favor with the learning single? Learning single just relied on two things. One is they have agreed with me. Secondly, learning single just was also made aware of the circular issued by them. They have produced a circular that page 1. That circular fairly covers this. We have gone to the circular on the last one. The circular says, in case there is a demand which then undergoes further change procedures as per statutory hierarchical departmental inquiry. They are talking about a situation where the demand itself is dynamic. From audit, it can become show cause, from show cause, it can become an order, it can become a second order, depending on how many appeals I have. That circular said, said the quantification deadline must be done. As of that date, what is the figure application? If their case is as of the date of the cutoff under SPL, their show cause notice is already come. Then I don't have a case to give. Their case is much after the quantification date, 1 year later.
Which stage the so-called notice comes? Form 1 or Form 2?
20.
By the time Form 2 issued,
Yes.
Form 3, they have not issued.
Our case was that the circular covers my case because the circular says.
What does circular say?
One more day. My audit inquiry of the date 2/7/2018. Subsequently, anybody does later sugar on the system. Some light on my audit inquiry. The audit inquiry itself is an item under which I can make it. And they follow on me again. I have not done so with my sugar on the system. Now, I think about the only difficulty where I was and the particular inspection from the department was doing case one.
So tell us one thing, in paragraph 5, the learned judge says, not a detailed order, the reasons order, everything. But would it not be that matter remanded back to pass a final order, but a reasoned order?
My submission that the learning citizen has quoted the circular application as part of the law. My submission only even in case matters to one, there cannot be a different time. That circular binds both.
No, you're right. Where is the circular? Let's see.
Legislation. It's actually, I'll tell you the topic. Jumble, my lords, it's 182, my lords. Circular.
Annexure J.
Annexure, yes, my lords. Sorry, I believe 214 of the new numbering, my lords. 214 of the new number.
What does this say?
Yeah.
The relevant portion is at subclause 5 minutes. For the purpose of eligibility under the scheme in some of the categories such as litigation, audit, inquiry, investigation, etc., the relevant date is 36/2019. However, it may so happen that the facts of the case may change subsequently. For instance, in a case under audit, investigation, or inquiry, that the tax dues have been quantified on or before 36/2019, a show-cause notice is issued after 36/2019. Similarly, a case is pending under appeal as on that date may attain finality in view of appeal over etc. It is clarified that the date, the eligibility with respect to category in such cases shall be as it was on the relevant date, 2019.
So what is the effect of this?
Effect I should only prove that I had a quantification prior to 30/6/2019 and as my lord rightly asked us, whether that quantification stands changed after 30/6/2019, but before I made my form 1 application. In our case, I have already submitted previously referred my form 1, form 2, TCA, notice. In my opinion, because they list out a few numbers based on whatever investigative material they say that they have gathered later. They try to improve their case from the audit to the proposal. The audit makes a final quantification until they come forward and pay this amount. Is 198, which is annexion M as per my reading, but 198 in the appeal. That will clarify my lord's query.
Which page?
198 in order of the appeal. My lord will kindly see form 2. It is issued by the department. Is the same figure 36,21,000. This is dated my lord's 23/2/2019.
Now, after this, form 3 will follow.
See, 1 year before show us this came to be issued. Not the key objective.
And this thing, circular, contemplates even if there is an issue of inquiry or so, that is at page 200.
214 minutes. 214 minutes.
2. Under the scheme, some categories such as litigation. Now this, so this circular contemplates wherever there is a litigation, audit, inquiry, investigation to settle those matters.
Because and then the scheme was published, they identified different categories of cases and the benefit for the discount that the scheme offers for each tax amount is different as per the different classifications. However, the policy decision seems to be like this. If I am voluntarily making a payment, I should get no deduction. If I have already taken time of the department or the judicial body and I am in litigation at an advanced stage, the discount is less. So for my category, the discount was 70% at the stage of audit, inquiry, or investigation.
Are you saying after 36/2019, no show cause notice could have been issued?
And only thing, once I make an application and it is accepted by each one to form 2, what happens thereafter is not right.
Lords, the contention taken by the department in this, my lords, is that the demand was never quantified. One, as per their own, the demand was never quantified, my lords. There was no written communication of the amount payable, my lords. In fact, the audit report, it was not a final audit report either, my lords. It was just a preliminary audit report that came to be challenged by the respondent also herein, my lords. Hence, there was no finality given to that. Before 36/2019, there was no finality given to that. Subsequently, this notice came to be issued, my lords.
Then why did you issue form 2?
That, my lords, I don't have an answer to that, my lords. That, in fact, the committee should have seen, because whether that could be accepted, those quantification could be accepted or not, my lords. That's the duty of the committee, which should have ideally overseen what other investigations are happening as against the respondent, my lords.
Then there cannot be a demand of me to make a payment. That demand is crystallized in the audit report itself at page 170 of the appeal memorandum.
Hence the assessee. Hence the assessee.
Hence the assessee is liable for recovery of service tax amounting to 3 crore 15 lakhs 10,072 in terms of provided of section 73(1) of the Finance Act 94, along with applicable interest. Assessee is also liable to make payment of applicable penalty in terms of section 78. Assessee is required to immediately pay service tax interest and applicable penalties and produce the challan evidence of payments. This is a definitive call for the demand. I would have only done 2 things against it. I would have either made payment without reference to the claim, but to my benefit, the government at that critical point introduced authorized. I could benefit from it. Had the scheme not been there, what will I be doing? I will have to follow the due course and the way.
My lords, in fact, there was an opportunity provided in that notice itself to respond to the same, my lords. 171 clearly, please reply. Yes, ma'am.
This audit report must be in place on 36/2019.
19. Prior to.
On that or prior to that? Audit report. But in this case, audit report was there on 18. Now, based on that, now does the audit report quantify which amount? Same amount?
Same category. Same as.
Now, this investigation, anything which comes after 36/2019 could not have been taken into consideration.
If my application under FPL is rejected, if they said the application is law for whatever reason, you are not the period is not identical to the period or whatever reason. If they reject it, then yes, we force.
No, once the rejection is, you are not being given the benefit. The scheme benefit goes where they will follow the normal channel, whatever it is.
Now, suppose the department said that this is not correct. I have a new quantification under the show cause notice. I am calling the audit. Don't pay under the audit. There is no such observation. The show cause notice inside stands on the legs of the audit report. They start by saying that there is an audit quantification. Okay. Now that we have come up with further information, we are expanding the scope of the inquiry. That is how the show cause notice is done. He does not say this has been resolved. This is accepted as a basic.
So form 2 is the quantification of the figure.
Yes.
Once you pay it by depositing form 3,
Get form 4.
then it is charged.
My lords, with respect to issuance of Form 2, I really don't have an answer, my lords, why the department has issued Form 2 when all these circumstances were prevailing around it, my lords. That for which I in fact asked the department as to what is the locus as to why the show cause notice has been raised. I believe they were not aware of these facts, my lords. Hence, Form 2 came to be issued by the designated committee. Subsequently, when these came to light.
Okay, let's read, keep it in the different. Yes. Now, there was an audit report of 2018.
Yes.
Much before that cutoff date.
Yes, my lords.
You could have rejected their case.
Ideally, yes, my lords.
You could have rejected
Yes,
their
my
case.
lords.
If you had rejected their case, there is no question of issuing a form.
Form 2, my lords. The department would be better placed if Form 2 was never issued, my lords. In fact, we are shooting at our own legs at this point, my lords. By issuance of Form 2.
Audit report also quantifies that figure.
It quantifies the figure.
You may have had some other source.
Yes.
To show what has been pointed out, figure may not be the correct figure.
Correct figure, my lords. My lords, in fact, the entire issue goes with respect to misrepresentation and fraud, my lords, and misdeclaration, which was a very serious offense to be considered, my lords. The show cause notice, the legs of the show cause notice starts from there itself, my lords. That is why the entire settlement has to be rejected is our contention, my lords. Since there is evident fraud and misrepresentation and misdeclaration.
You file objections there.
My lords, before the single judge. Yes,
judge.
yes, my lords.
Does not find a mention in the rejection.
Correct.
To be better their case in statement of objection or subsequently on appeal. I do not think it's possible because the rejection letter is categorically being on 290. when there is a show cause notice, that show cause notice is given for higher quantification, therefore we cannot accept your form of notification. Whether they have taken a condition subsequently or not is up to them. But my lord, to be fair, the scheme also contemplates a situation where in case, even after form 4 is issued, they realize that there is any fraud or misrepresentation based which the declaration was made at the first instance, they can recall by form 4. That is open under the scheme.
So is it open? Where is that? Now, Pella, if it is open,
Yes.
then you can go ahead.
Yes. My lords, the department should think about it, my lords, at this point, so.
Right? You don't want to put words in his
Yes.
mouth. But surely if that is a
Yes,
contemplated,
yes, my lord.
then it's not, see, then you are not, your rights are not foreclosed.
Yes, my lords, fairly agreed, my lords. If there's an option to reopen,
Where is that? See, we thought we are under the impression once declaration, once form 4, no further action.
no further action, my lords. That is the general. But with respect to fraud and misrepresentation, my lords, department obviously has a opportunity to come.
Is the power there?
My lords, the power has to be seen from the. My lords, section 129 clearly goes on to say, every discharge for certificate issued under 126 with respect to the amount payable under the scheme shall be conclusive as to the matter and time period stated therein. And declarant shall not be liable to pay any further duty, interest or penalty with respect.
Why we are saying is this, your question. Team comes, apply, there is an error at their end, they have given form 2. If they had not given form 2, that means they don't want to proceed under this scheme.
My lords.
Why I'm pointing this out? My understanding that every time the form 2 was issued, they were not aware of the show cause. Point number 1, my form 2 is being issued to me on 27/2019. Show cause notice is of the year 2020, 2020. Of course, they would not have been aware of the show cause. Section 126, at page 179 of the appeal memorandum. This is part of the scheme. Designated company shall verify the correctness of the declaration made by the declarant under section 125 in such manner as may be required. Provided that no verification shall be made in cases where a voluntary disclosure of any amount of duty has to be declared. The only exception where verification could not have been done is in case of voluntary disclosure. I am not under that category. I am under the category of audit inquiry. First voluntary disclosure, then audit, then OI.
There is that just shows that. I think that has been. That clause 5. Litigation, audit, inquiry, investigation. Audit and?
Investigation.
Audit has a different definition under subclause G of section 121.
So this is not voluntary disclosure. So except that, they can go ahead.
They have to make a verification of my declaration under 121. Shall be. Once this correctness of my claim is verified, they are satisfied, only then form will be issued. Now it is not open to them to go back and say, this is doing, it's not a question procedure. This is a thorough investigation of what is doing.
No, you are right. The only thing is why that form was 2 was issued.
My lords, that the different heads of the department was functioning parallelly, my lords. In view of the same, the committee might have not seen this coming also.
That's one thing. Will that be a reason to reopen everything?
My lords, that ideally speaking, my lords, our contention at this point is only on the ground that fraud and misrepresentation, which is evident.
But if that be so, then everything would be open. What is
My
the
lords,
purpose of the
yeah,
scheme?
Ideally speaking, my lords, yes. The entire purpose and the objectives of the scheme is going to be defeated, my lords, in the long run, if that is.
Every time you'll bring in this.
Based on decisions which talk about the benefit of the scheme, the objective of the scheme, how it should be read. I had page copies for my learning friends. If I can only pass on the direction.
Okay, just a minute.
Bombay and Delhi metros are the
We'll do one thing, we'll just have it tomorrow. We have one more matter. We'll just say tomorrow, just re-notify tomorrow. Give us the deadlines. Just put it away. No, scheme, the purpose of the scheme, you can't actually, the purpose is the beneficial in the sense that who wants to avail the benefit, get advantage, one can do it. Here is a person, you want to take benefit of the scheme. And you made whatever the steps you have to take. They say the benefit could not have been given possibly in this case. But the fact remains they have acted in furtherance of the giving benefit of the scheme. Now they can't come out of that saying that much after the cutoff date saying that we want to.
Yes.
Then if this be so, what are you concerned also? Then it's like this, though I have given the benefit, I can recall.
That part is not there, my lords.
Just tomorrow morning, we'll have it. Tomorrow morning. We'll take it up tomorrow morning. Okay.
Obligations.
Serial number 2.
My lord, I appeal for the respondents.
But the issue here is, or rather the issue in the writ petition was whether the petitioner is entitled for a refund. To understand that, we need to see the petitioner made the payment as what? Admittedly, the payment was made under 74(5). This is an admitted position. The petitioner says, yes, we made it, but the petitioner's contention is we were forced under duress, we made it. The petitioner admits that it was made under 74(5). That is the clear stand in the affidavit as also the writ petition. But the justification is that it was made under duress. So therefore, if we remove the duress, then it is a payment made under 74(5), which cannot be refunded now because it was paid under 74(5). I will take your lordship through the provisions. It's a clear admission. Now, whether duress, my lord, I have various authorities. The standard of proof for duress is clear and convincing evidence. And the Supreme Court has repeatedly said that the High Court cannot go into disputed questions of fact. Now, last time I took your lordship through several parts of my written statement of objections before the learned single judge. The object was thus to show that I have denied the allegation that there was duress. When there is one party who makes a material proposition of fact and the other party denies, my lord, there has to be a recording of evidence when there is a disputed question of fact. But the single judge just brushes aside everything and he says duress is established. To that extent, my lord, single judge's order is wrong and which requires setting aside. And my lord, and there one more issue. I went through the
independent of duress, that we have put it to us. See, duress, coercion, these are something, allegations akin to malafidance.
Yes.
You want those officers seek their rights.
Yes. Yes.
What has been argued by the council is, divorce all these things, independently also, other than that also, this impugned action is wrong.
Why not? I mean, the contention was that it was the petitioner was trying to wriggle out of the contention that it was made under 74(5). But the admitted position in the affidavit, it is paid under 74(5). I'll take your lordship through that. And before I start reading, my lord, there is one more submission that I want to make. But I went through the affidavit as also the statements in the writ petition. The allegation of duress is only for the purpose of recording the statement, not for the payment. The statement of the proprietor of the petitioner was recorded. I went through, my lord, twice to ensure that I'm not wrong. There is no allegation that the payment was made under duress. The allegation of duress is only for recording the statement. That distinction, my lord, I want to show to your lordship. There is one reason why, my lord, on prima facie, the duress allegation will have to be rejected. The payments were made in two tranches. The first one was made on 30th of July. The second one was made on 3rd of August. The petitioner in the affidavit says that because of duress, the payment was made on 30th. And then petitioner says, I went and met my chartered accountant. Chartered accountant said, Are Baba, these are payments to be made only when there is fraud. You are not committed fraud. Why did you pay this? He says so. And then, my lord, 4 days later, the same situation takes place. Can anybody buy such an argument? Nobody will be fooled twice. If there was duress once, and if there was a consultation with the chartered accountant, nobody goes a second time and does the same mistake again. When the chartered accountant is already cautioned, these are all, my lord, this is not my submission. This I am reading from the affidavit filed by the petitioner. So please take the the affidavit, my lord, filed by the writ petitioner, and please see the admissions made.
Just give us those judgments, everything, the file, everything. So these are the citations.
Well, I'll answer the authorities, my lord, in due course of time. If I may take your lordship through the so-called affidavit. In the paper book that is given to me, the page number is set to be 182. But I doubt that is correct because several pages were missing in my copy.
Huh? What has not annexed?
Oh, acha, so even in the court copy it is there. Oh, it was there in the writ petition, is it? Or then it is, yeah. Okay. Then I think Jeevan's office would have missed it. I'm sorry about that. Please have a look at the affidavit.
Affidavit of?
Affidavit filed by one Priyesh Shashikant Nanavati, said to be the proprietor of the petitioner. It is presented along with the writ petition as Annexure H. Annexure H. My lord, since the one produced in the writ appeal does not have all the pages, now a complete affidavit is being handed over. So please have a look at that. I will not read the entire affidavit. Para 4. I say that I am making this affidavit at the earliest possible opportunity. To me, since 29/7/2021, I have been under extreme pressure and faced financial ruin due to, my lord, kindly note this, due to illegal action of GST Investigation Authority as narrated herein below. Now, my lord, I'll pause here for a moment. Please go to the last page. It is sworn on 10th of August 2021. Now, my lord, it is not comprehensible as to why this affidavit was made on 10th August, while the writ petition was filed on 16th September. Lordship will kindly note the date. On 30th July, the first payment is made. Between 30th July and 3rd August, date is not given. The petitioner meets the chartered accountant. And chartered accountant cautions that you should not have made this payment because this is to be made only if there is fraud. And 3rd August, the second payment is made, despite the chartered accountant caution. Then 7 days later, this affidavit is made. And between 10th August and 16th September, no effort is made to file this before the authorities. My lord, duress, my lord, it is like the golden hour. You have to take action immediately.
No, this affidavit was given to whom?
Nobody. It was given to nobody except to your lordships when the writ petition was filed. And I doubt, my lord, this was actually made on 10th. These days, I mean, with due respect to the notary, I have come across cases where predated notarizations are made. So this is made, it is made on 10th August. Now, if it was made on 10th August, why I'm raising this doubt is, I'm backing my...
It was not given to you.
No, it was not given to me. It was not posted. It was not hand delivered. It was not sent by email. For the first time, it is produced as an annexure to the writ petition.
Yes, 1 minute, Ms. Kam. Yes, ma'am. What do you want to say on this?
Because the protest letter itself was not accepted, my lord. On 3rd August, I went with the chartered accountant. When I was sitting there, the payment was forced to be made by my office in Mumbai. The CA said, please accept our protest letter. That is also not taken. That is part of my affidavit, my lord.
No such statement is made in any
And how was
affidavit.
the payment made? Should be
This is a
seen, my lord.
counsel submission, no such statement available in anywhere.
My lord, please.
Lordship, I'm
Did
aware
you-
of the
did
affidavit. I
you-
will
did
explain.
you-
Lordship. Let us
now
read
tell
the
us one
affidavit.
thing, just
Lordship,
1 minute,
The
please.
letter ASG is misleading the court. I'm sorry
Just
to say.
listen to the court.
Oh,
please.
stop saying that, please. Stop saying that, yeah.
Tell us one thing, when was the first payment made?
My lord, on 30th
30th of July.
Yes, my lord.
When was the second payment made?
3rd August, I was called there by summons.
Very well. So between 30th and 3rd August, you had no issue.
No, it was not no issue, my lord. I had no courage to do anything. And there was nothing available with me, my lord.
Pardon?
And my phones were with them. My phones were confiscated.
Phone is with the,
It was
Sorry.
confiscated by them.
this
On
is
the
not made on
midnight.
the phone. I mean, this is made in some computer.
Very right, very right.
My lord, yes, of course. My two phones,
No, 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 no. If you had any grievance,
my lords.
the phones have been taken away, all those things, the means of communications were shut. But you were not detained in that sense.
My lord, 2 days I was detained in the office.
Which days?
29 and 30th.
So we are talking of post 30th, before the
My
second
lords,
payment
yes.
was made on 3rd August.
Yes, yes.
You were not detained, you were there, you are a free person. And at no point of time before 3rd August, we are just only putting it to you to
My
so
lord,
that
yes,
we can
please, I
elicit.
appreciate, my lord.
We elicit your stand. So you had no issue till 3rd August, in the manner what has been said in the affidavit. Now, between 3rd August and 10th August, there's a gap of almost a week. So during that time also, you did not express yourself. What has been done by you is under coercion. We just wanted to elicit.
And between
stand.
10th August
May
and
I,
16th September,
And this affidavit which you have shown on 10th August, was it sent to the authorities?
No, my lord, they refused to take any paper. My lord, let me point out.
that statement is not
made
available.
it very clear in the affidavit also, my lord. On the day they went out threatening me as an arrest that unless you make payment within 12 hours, we will arrest you. I managed.
But now
In
I'll
my
resume
bank
my
account, there was,
submission.
in my bank account, there was no balance. I had to borrow, made 1 crore payment. My lord, I am a small person in the COVID time without any phones, etc. I was actually stunned. Now the summons are issued. Come immediately. Summons were on 2nd, immediately next day. I said, give me 1 day because I'm not even getting, my lord. In the COVID time, traveling by plane was also not possible. The tickets were also not possible.
No, it's all
And
right.
still
We
I
are only-
went there. My lords, as I have stated clearly in my affidavit, my lord, I was absolutely ruined because I had no, my lord, my gross profit in a year is 50 lakhs.
Ms.
My all cash flow is gone.
Bandhika,
My lords,
we are just only asking you this.
my lords.
Between 3rd and 10th,
Yes.
you did not really took up this issue with the authorities also. Neither you approached the court.
My lord, I was already back to Bombay. Then I had to go back to them. I was back to Bombay.
You were back to Bombay, you're right.
My lord, yes.
You're back to Bombay. Bombay, Bangalore, anything, but you did not. But when this affidavit was on, did you send it to the authorities?
My lord, I was waiting for the second summons. It never came. And then I had to file a writ petition because
Summons for?
my lord, they had said, now we'll call you again within a week's time. I said, okay, call me whenever you want. It was all over. They never called me. And within 1 month's time, I filed a writ petition, my lord.
Okay.
My lord, it's not a big corporate who
There are
has
4 of
multiple help. It's one small person, dealer who has no help. And he has tried to do the best in his situation.
Very well, we got it. Yeah. Yes, Mr.
Lord,
Kar.
if your lordship would now take the affidavit. Paragraph 5. I say that I was visited by the investigation branch officers of Bangalore unit on 29/7 by the above mentioned DGDSG investigation unit at my office at 9:30 a.m. in the morning. Total of 5 officers visited my office, whose full names I do not remember right now, but the main officer was Harsh Katara. As far as other officers are concerned, I only remember their second names. As they were introduced to me, they are Mr. Pawar, Mr. Chaudhary, Mr. Jion, and Mr. Bhaskar. Then my lord, para 18. I say that at 2:30 PM on 29/7/21, investigating authorities took away my 2 mobile phones, so and so. And then okay, para 25. I say that later at night at 12:30 AM on 37, they stated that they are too tired and 2 officers decided to sleep in the office and refused to let me go outside my office, effectively detaining me for the night in my own office. My office is so and so, so and so. And then para 30. For the entire day, the officer kept on insisting that I pay the entire amount of 4.88 crore without any calculation or adjudication. Otherwise, they will arrest me. And next para, 131. I say that 4.88 crore is a massive amount beyond my capacity when my yearly profit is 40-50 lakhs, so and so, so and so. Para 34. In the end, having no option but to buy peace, I offered to arrange funds to the tune of ₹1 crore and pay the same under protest. I say that eventually the officer relented and stated that they shall prepare my statement without my inputs as per themselves, made me forcibly sign. The statement was made on 31/7/21. The investigation visit culminated. But the writ petitioner admits the culmination of the investigation.
But tell us one thing, under what head you have claimed this amount? Whatever.
74.5.
Huh?
74.5.
74.5.
We have received it as 74.5 when we received it.
Huh.
As a voluntary payment. May read and then make my submissions. Not many paragraphs, only a few relevant ones. I am now reading para 35. The statement was made on 31/7. The investigation visit culminated when I, under tremendous duress and mental trauma, agreed to sign the statement, which was prepared by them, along with only few cosmetic changes like so and so, so and so. The investigating authority also ceased purchase invoice. Please, Lord, I'll read that again. Under tremendous duress, I signed the statement. So the duress is for the statement. And then, my lord, let me read further. There is absolutely no mention on how that payment was made and from which place that payment was made. I'll read further. I say that I was forcefully directed to make the payment under 74(5) of the CGST Act, and the officer also refused to accept a letter that the same is paid under protest. I say that later, my chartered accountant informed me that the payment under 74 is a payment made for demand, which is payment made for demand raised by way of fraud, willful statement, or concealment. I say that this section was deliberately enforced upon me to entrap me without any proof. Lord, I'll pause here for a moment. Between para 35, 36, and 37, somewhere the statement was taken and the payment was made by the petitioner from his office by logging into his system or wherever. The writ petitioner does not disclose that. He says, later my chartered accountant informed me that the payment is made under so and so. By the time the petitioner met the chartered accountant, the payment is made. No, this is a very important one. The petitioner has suppressed the circumstances under which it made the payment. It is not that the officer held a gunpoint or said, I'm going to arrest you, please click the button and make the payment. No. The investigation culminated with the taking of the signature on the statement. After that, the petitioner was free to go to his home or office or wherever. From there, the petitioner has made the payment. So where is the duress for making the payment? There may have been a duress for recording the statement. But statement, obviously, the statement has to lead to some other positive action. Now, my lord, please have a look at how the second payment is made, para 38 onwards. I say that the investigating authority had forced me to sign the statement and not even provided copy. Once again here, the force is for signing the statement and not for payment. I say the statement given on so and so date contains coerced admissions taken from me. And then I say that I have done genuine business, so and so, so and so. I say that the statement taken on 31/7 was given under tremendous coercion and grave threat to my freedom by constant threats of arrest. There is nothing like non-genuine business by me. The goods supplied are actually received by my customer. Once again, in para 40, the allegation of duress is for recording the statement and not for the payment. Para 41. I say that I demanded cross-examination of the so-called committal statement of Vijay Kumar Gupta, partner of the Raj Chemical, since it was on the basis of the statement that my ITC. My lord, I will pause here for a moment. A party who can demand a cross-examination, which is a legal, a judicial process, should obviously know that there is something called register post acknowledgement due. That if you can always prepare a statement and post it to the authority on the same date that the duress is made. If you know that there is something called cross-examination, you would obviously know that you can post it through register post. Then para 42. I say that the entire statement dated 31/7 was a statement which was not voluntary. It was drafted by the officer and I was forcibly made to sign. I say that I hereby deny all admission made in the statement since they were not made by me voluntarily. I have made genuine purchases.
Is the statement on record?
Yes,
it is.
okay.
Show us that.
Yeah, it is. It would be there.
No, statement given to the officers.
I believe it has been produced. I believe it.
We want to see that.
But I'll.
Yeah, you
yes,
go ahead. Just take out that statement.
Sandeep will find it. Till then, my lord, I'll read the further paragraph. Now, my lord, the second tranche of the payment is interesting. Till then, your lordships have seen repeatedly the allegation is that duress is for signing the statement, but not for payment. Para 44. I say that the payment of 1 crore was paid on 31/7 under section 74(5). My lord, please note this. The payment is made under section 74 by me, but the same was in fact coercively recovered from me. There is no statement that the payment was made under duress. It was coercively recovered from me by the investigating authorities under constant threat of arrest. I say that the collection is illegal and I have not availed any incorrect input credit either by of fraud, so and so, so and so and so. The issued summons for attendance on 2/8, but the time was short and I had been subject to incredible discomfort and I requested to be allowed to come on 3/1. Now, there's one more development. We issued a summons and said, please come and appear before us on 2/8. The petitioner says, sorry, I've got some difficulty. I will come on 3/8. We allowed that. So here is a party who knows to demand cross-examination, who knows what is
the cross-examination demanded?
As per the, I say I demanded cross-examination, but this is on 31/7. In the as per the statement made in the affidavit.
Which paragraph, Mr.
41, my lord. 41. I say I demanded the cross-examination of the so-called committal statement of Vijay Kumar Gupta. Anyway, now, my lord, please have a look at the statement regarding the payment of the second tranche at para 45. If your lordships could now kindly turn to para.
Yes.
I say that the officer once again called me on 2/8 evening and asked me to come urgently to Bangalore office on 3/8. I say that thus, without any reason, I had to rush to Bangalore on 3/8/21. When there is a summons issued and the party says, I will come the next day. And please look at the next paragraph. Without any reason, I have been called. These are quasi-judicial proceedings. I say that on my reaching Bangalore, I was informed that they knew of my debtors who belong to the same group at Hyderabad, so and so, so and so. I say that all the above 3 companies belong to the same group. Lord, we can probably skip that. Let me read that. I say that all above companies, 3 companies belong to the same group by MSN group of companies and I've got a common CFO. I was informed by Shri Amardeep that he knew CFO and he had a talk to CFO without my permission. No order of attachment is passed in my case, but yet I was surprised that he ordered to the CFO to release the above mentioned funds and directed all 3 customers to pay the total amount immediately in my account. Total about 1.5 crore is recovered by officer without notice, without my permission. As per the directions of Amardeep Sangwan, the debtor had to make the payment in my account. The dues were pending since last 6 months and the same came to be proven from my books of accounts. I was forced to follow each and every directions and whims. I did not have my phone from 37 and I had made no contact with the debtor. I was once again threatened with arrest if I did not make the payment of rupees 1.5 crore, which was paid in account at the behest of Mr. Amardeep. I was clearly told that I would not be allowed to leave the Bengaluru office or collect my seized belongings till the amount is paid under 74(5) as coercively directed by the IO. My plea to consider the same under protest and keep it in writing was also denied. They also made me sign another statement which had milestones of me agreeing to make additional payment every 15 days. I said that the officers kept telling me that I have a target which must be completed and it is for that reason they would ensure that I make payment of such amount by hook or crook so that they can show the same as recovery made by them. I say that such behavior is unbecoming. I say just like the statement on 31/7, this statement on 3/8/2 was drafted by the IO without recording and considering my statements, any statements of mine denying the allegation. I say that both the statements dated 3/8 are not voluntary statement by me, but are signed by unimaginable duress, threats of incarceration, blatant use of authority and mental torture. I am swearing to this affidavit to deny the allegation by the Bangalore DGJ officers and also retracting both the statements on 31/7 and 3/8 as the same were taken under tremendous mental torture, threatening behavior of the authorities, which amounts to nothing short of abuse of power by investigating officers. I reserve my right to retract each and every purported admission by me, so-and-so. I also demanded my right to have a copy of the so-and-so. That may not be necessary. I say that the business in chemical so-and-so, so-and-so. Nowhere there is any statement on how that second 1.5 crore was paid.
When was it paid?
3/8.
3/8.
He does not say.
I have
We
said,
say nothing on the affidavit according to.
There is nothing about the payment. There is not a whisper that the 3.8 was, there was duress to make that payment, in the sense that he was made to sit along with the computer, to open the portal, to fill in that challan and to create that GST 03. None of the statements are there.
Okay.
So therefore, my lord, your lordship will appreciate, there are so many dots which can be joined together. Number one, that a party who knows various processes in a quasi-judicial proceeding does not even post any notice after 31/7, does not post it after 31/8. He knows how to make the retraction. He knows how to make the retraction. He makes the retraction on 10/8, but does not post it at all. Till 16/9, when the writ petition is filed, he does not post it at all. He meets the chartered accountant before 3/8, but yet once again commits the same mistake of making the second payment. No, these are all cannot be believed. And the learned single, please see now how the learned single judge just brushes aside. By throwing to the wind established principles, the learned single judge straight away believes the writ petitioner. No, that is where, my lord, I am requesting your lordship to set aside that part of the learned single judge's order, because he strays away from established principles.
Now, what do you say on the authority relied upon by?
My lord, that bundle is in my favor.
No, the
Swiggy bundle authorities, it is in my favor. The second issue that was framed by the coordinate bench of this honorable court, the second issue has been
the one she relied upon, this Lovelace single of the Delhi High Court.
Lord, this Lovelace probably, with just 5 minutes left, I'll come back. Lord, I believe the bundle technologies writ petition was also relied upon, judgment in bundle technologies. Writ appeal. Lord, this is straight away in my favor. Please look at the issue number 2.
Where, which page?
But you have relied on bundle technology.
180. Letter submissions.
Page 1. Other number could have.
Pages.
There are 15th bundle technology. Bundle technology.
Sorry. Sir, 180, my lord, it is a learned single judges.
171. Begins at 171. The relevant para would be 15. 15, yeah. Please look at the issues framed by the honorable bench. Number 1 would be whether the amount was voluntarily paid during the investigation by the company. My lord, this is on facts. We can skip that. Please look at the second one. Whether the amount was recovered from the company during investigation under coercion and threat of arrest. My lord, please see how the honorable bench deals with that particular issue.
So in any case, according to you, even this court, see, if it is threatened coercion, surely a mala fide action. If it is a mala fide action, it is an exception to bona fide. If it is exception to bona fide, it is contrary to the law. Then need to be refunded. See, everything in, if you put it in a chain and there is a finding of fact.
No, Lord, finding of fact in that case based on the facts in that case.
That's right.
Yes.
That's right.
Yes.
What you are arguing it, surely not in this case, there is nothing coercion.
Yes, for the payment, there is no coercion.
Okay.
I'm going by the very highly doubtful affidavit. Even by the statements made in the doubtful affidavit, there is no coercion for the payment, other than a bald statement, that there was a threat of arrest. Please see how that second issue was dealt with. That has been rejected. Lord, please turn to para 25. Para 25 in the bundle technologies judgment.
Just see para 19 also of this.
I'm sorry, Lord, so I'll take your lordship there.
The issue which arises for his amount has been paid by on ascertainment under section 74(5) of the, in the instant case, there is no material on record to indicate that the amount of this which were paid at about 4 AM and respectively were paid on admission by the company about the liability. There is no communication in writing from the company to the proper officer about, now this is what being said.
True, but my lord, my respectful submission is there no such communication required in law. The law does not contemplate any additional communication. Just submission of that GSTR 039, what is that form number? Just submission of that GSTR is sufficient enough. The law believes that it's a voluntary statement.
No, what is being said is this. Is if forget coercion, everything.
Yes.
Let's assume it's involuntary or they have made certain payments. You can argue if it is not coercion, there is a payment which has voluntarily made.
Yes.
If it is voluntarily made, there is sort of an ascertainment under
Yes,
74(5).
that's my submission.
That you can argue.
Yes, that's my submission.
Very.
That's my submission.
What
And
is-
my lord, here, para 19, their lordship's conclusion that there is no other material, my lord, I would not agree with that. No other material is contemplated in law.
No, what is being argued was last time, when the amount comes, you will acknowledge that this is under 74(5), saying that, yes, this is an ascertainment. If you acknowledge and possibly a sort of a receipt, a sort of an acceptance clause.
I got it. My twofold response to that. Number one, my not issuing GSTR 04 does not in any way change the nature of payment made by the petitioner. My failure to acknowledge, even assuming that there is a failure, my failure to acknowledge will not change the characteristics of the payment made under 74(5). And number two, my lord, I will not issue acknowledgement until the whole payment is made. This is not the complete payment. I would have issued, because as per the affidavit, I had given them another, I had said, you pay within another 15 days time. That is what the affidavit says. The balance amount, they said we were forced to pay. So if that entire 488 was paid, I would have issued the acknowledgement once for all.
Now the balance would be through the show cause notice and through the normal process.
No, we would, because the writ petitioner rushed to the court.
Yes.
We had to issue the show cause notice. Otherwise, we were awaiting payment of the balance so that we could issue the GSTR 04 acknowledgement.
Acknowledgement.
Yes.
But he.
My lords.
1 minute, we'll come back to you. We'll come
Okay,
back.
okay, as my lord, please.
Yes.
Now, how would you recover the balance?
By issuing show cause.
That's the normal process.
Now we have, after my lord, the writ petitioner dishonored by rushing to this honorable court, we have now initiated the regular process under subsection 1. We will now proceed under subsection 1 because the writ petitioner now says it is not a voluntary payment now, which is as an afterthought.
So according to you, it's as good as not paying whatever he is entitled to. Whatever he has paid, 2.5 crores or 2 crores, it's not the full compliance.
Yes.
That's according.
Full compliance would have been 4.88.
4 very well. Though according to you, it's voluntary, but still he has not paid it, resiled out, went to this court,
Yes.
you have to follow 74.
Yes, my lord. Yes, that's my submission. But my lord, I'll once again re-emphasize that non-issuance of the acknowledgement does not change the characteristics of the payment made by the petitioner, which the petitioner describes in the affidavit as under 74(5). On affidavit, the petitioner says this is a payment made under 74(5).
Very well. So, okay, fine. Where are the statements recorded? Why the statements were not filed?
Not the writ petitioner, he should answer.
I know, we are asking him only.
Lordships, the statements are never given at that point of time. Once the writ petition was filed in September 2021, there were no statements. The statements were given along with the show cause notice, which was issued 1.5 years later. 1.5 years later, correct? After 1.5 years later, show cause notice was issued 1.5 years later, after the writ petition was filed.
We are just simply asking why were they not annexed along with the writ petition?
Lordship, there were no statements given at that point of time. The statement was not given to me at that point of time.
They were given.
When were the show cause notice issued?
November 22, and Lordship, the show cause notice is on record. We had given it to the single member bench.
Right. So can we take it? Were they issued, the statements were given along with the show cause?
Yes.
Later on.
Now, the show cause was the subject matter of the writ petition?
No, my lord. My lords did not want to go in the merit at all.
Okay,
It was
very
just
well. Let's
pointed
take
out
it.
the ascertainment.
Let's take it.
My lords.
But when this writ petition was filed,
My lords.
surely the statements were in your possession?
No, my lord. They were never
was
given
not.
to me. No.
Okay. When was the show cause notice issued?
November 22. My lord, I'll give the exact date.
November 22.
My lords, yes.
Yes, November 22, my lord. Page number 15 in that compilation.
Okay. November 22.
30th November 22. My reply is serial number 2, my lords.
30th November 22. Was it not placed before in the writ court, before the learned judge?
My
Even
lord,
after
yes.
you have
My lords did ask for the ascertaining the self-ascertainment as to what was in the show cause notice, whether this amount was excluded or not. He specifically asked for that.
G1 says it was handed over to the learned.
My lord, yes, we have handed over.
Okay. Very well. Anything else, Mr. Kamath?
Lord, I may need about 10 minutes.
Oh, yeah, go ahead.
Lord, this loveless judgment, my Lord, if I can cover, Lord, I did not have the benefit of going through that.
We will have it tomorrow.
I may just need 10, 15 minutes.
We'll have it tomorrow, ma'am.
My lord, I am in little difficulty. I have some medical exigency I have to attend to. Can we have it on Friday?
Anyway, this is my reply. So
no, we want to have some clarification from her.
Friday.
No, then when do we have?
Friday is okay, my lord, or next Monday, whatever suits my lord.
Not Friday.
Whatever suits my lord.
Wednesday, Thursday is fine, not Friday.
We can have even Thursday. Friday, Mr. Kamath has difficulty. Thursday will suit you.
My lord, Thursday will suit me.
Okay, we'll have it on Thursday.
Very well. Very well.
My lords, I am traveling to US. My associate will also be there because the papers would be here with him. But I will be available online.
Thursday, we say Thursday.
My lord, yes, I'll be available online.
Just re-notify. Just we have heard Mr. Kamath learned ALT for some time. Re-notify on Thursday for further argument.
May we have it preferably in the first half or
Ma'am, do one thing we'll do. If matter reaches in the first half, we will not pass over. You can, if it is comfortable for you.
My lord, I'll make it comfortable.
Convenient, fine.
I will make it comfortable. Don't worry. Obliged, my lords.
Thank you.
Obliged.
Just leave it.
I will discuss more. I'll discuss more.